For judgment, item 1.
In view of the observations made above, the writ appeal is dismissed.
Much obliged. Much obliged.
Aizel bench for judgment, item 1.
In the present case, it is seen that the plaintiff respondent has not adduced any evidence in support of his claim. In fact, the plaintiff has not discharged the initial burden in view of Section 101 of the Evidence Act. For the reasons mentioned above, the impugned judgment and decree dated 27/8/24 is quashed and set aside, and the appeal is allowed.
Great.
For admission, item 2 and 3.
The rest of the pages I'll sign later. Okay? You just send it.
May I please your Lordship?
Yes.
Lordship, I am appearing on behalf of Sanjay Kumar Medhi for respond number 5. Lordship, kindly pass over the matter for the time being. He is before the idle bench only. He is in court number 1, Lordship.
Okay. Call after something.
Item 4.
Respondent's notice is complete.
My lord, I have just received a word that the respondents, the deputy
Yes.
commissioner has is yet to disburse the check. So if we can have the matter listed on Friday, so that the matter can be closed if the check has been disbursed to the petitioners, my lord.
Okay. Learned counsel, Miss Emily
Valentina.
Valentina submits that the deputy commissioner is yet to disperse
Yes, my lord.
the checks in respect of the compensation for the petitioners. Stop. Accordingly, she has paid for listing the matter on Friday, 31st, for necessary orders.
My lord, much obliged.
Item 5.
May I please your Lordship?
Yes.
Lordship, similar pair for item number 5 to 13, Lordship. He will appear in this all this matter, Lordship. He is coming.
No, but have you filed your affidavits?
Your Worship, in these matters, there's a writ appeal pending in the principal seat regarding,
Okay, challenging the single bench
Yes.
judgment. Then in
regarding
that
payment of
case-
interest under section 34. I think my learned friend has.
Then in that case, can we pass an order saying to list it after the disposal of the,
Your Worship, my learned friend has a date on which the writ appeal is to be listed.
okay,
So I think he
okay.
has a date which he wants to be listed on. Then-
Okay then. We'll call after some time then.
Yes.
For orders, item 14.
My lord, this is a jail appeal and
It is ready.
yes.
What
Well,
about the
otherwise ready.
paper book? Have you received?
Yes, my lord.
Paper book received?
Oh,
I believe so, madam. It's
We'll-
taken up by Miss Mary. She's on
Okay.
that.
Learned counsel for the appeal. Are you appearing as amicus?
yes, my lord.
Learned such and such, learned amicus curiae for the appellant as well as Miss Linda such and such, learned PP is present. The paper book is ready. The matter may be accordingly listed for hearing in usual course. It is submitted that the paper book has also been received by the counsels for the parties. So, list for hearing in usual course.
My lord, obliged.
Item 15.
My lord, this item may be passed over for the time being. Miss Mary is on legs. Miss Vanessa is on legs, ma'am.
Okay, thank you. Call after some time.
Item 16.
It's a similar one. Hold on.
Yes.
Item 16
My
also.
lord, for this item number 16, my lord, there is no LCR, but as per the order dated 6/10/2025, it has been clearly reflected that the LCR may be called on
Order dated
6/10/2025.
Okay. By an order dated 16/10/2025, this court had called for the scanned copy of the TCR and the CD. So, however, the same has not been received. So, learned counsel for the petitioner, Mr. Such and Such, is present. Also, Miss Linda, learned PP is present. So, the registry shall issue another reminder, a reminder for the TCR and the CD from the learned, which court? From
The Special Narcotics Court.
From the court of learned special judge. Where is it? Special Judge NDPS, Aizol.
Yes,
Aizol,
yes, my lord.
yes. Stop. And list the same after 2 weeks. 2
My lord,
weeks.
1 week.
1 week. List the same after 1 week. Yes.
Obliged, my lord.
Item 17.
Your Lordship, similar pair for item 17.
This is also arising out of the same case, or this is a different case?
This is a separate case, Your Worship.
Separate
This is
case.
an appeal in a
Okay.
suit. And Your Worship, just now my learned friend spoke to me. He said that he wanted to file an application for submission of additional documents.
Okay. Otherwise, what is the IA for? Continuation of
Continuation
delay.
delay.
In the IA, he wants to file additional documents.
Yes.
Okay. Head Learned Counsel, Mr. A.R. Malhotra, for the, you are for the
I'm for the private respondents.
private respondents number
2 to 43.
2 to 43. 2 to 43. Stop.
He's just come.
Okay, okay. Learned Counsel for the applicant appellant, Mr. S.K. Medi, submits that, praise that. Item 17. Item 17.
17, my lord, is I'll file one additional affidavit, my lord.
You have filed or you're going to file?
I'll file.
You want to file?
Time may be-
That he praised that he may
Additional
be
affidavit, my lord.
allowed to file an additional affidavit, bringing on record some additional documents.
Yes, ma'am.
Bringing on record
In
some
Miss Lina's case, ma'am.
additional documents in the IA 172 of 2025. This order is in 172, okay? So accordingly, the prayer is allowed. List when? After a week?
My lord, this matter I fixed on my lord days 21st of November, my lord.
21st of November.
Yes, ma'am. Today it is my lord 28, my lord. October. 2 weeks after 2 weeks.
On 21st of November. That is after 3 weeks. 21st of November 2025. Yes.
Item 2V3.
My lord, item number 2, my lord, days we filed, my lord, we filed a review petition, my lord, as per, there is an order, my lord,
Okay, you prayed for time to file a review petition.
Yes, madam.
So that has been filed.
Yes, my lord. This review petition number is my lord 25. Dispose of this matter. So, my lord, this matter maybe my lord is because this matter may
No,
come.
we'll say to list it after the disposal of the
Yes, my
review.
lord. So, my lord, this matter may come, my lord, December, my lord, December, my lord, because this now already November is coming, my lord. Matter may be
First week?
5th of December, my lord.
Why 5th? Let it be on 3rd or something, 2nd or 3rd.
2nd or 3rd, my lord.
5th is a Friday.
2nd of. Second of yes, my lord. 2nd of second.
Second. Learned Counsel, Mr. S.K. Mehdi, appearing for the respondent number 5, submits that a review petition being number 257/2025 has been filed in against the order dated 19/3/2020 passed in WPC 148/2019. Stop. Accordingly, the Learned Counsel prays that this matter may be listed on 2/12/2025. Stop. Learned Counsel for the petitioner, Ms. Valentina Laltin, who is present and has no objections, list on 2/12. Yes.
My lord, with respect to the item number 3, the matter has already been dismissed
my
and
lord, that is
disposed.
disposed of,
If
my
the
lord.
matter may not be listed again, my lord.
Yes, my lord. This is already disposed of, my lord.
Which one? Item 3?
Three,
Yes,
my
my lord.
Okay. Item 3, that is WPC 112.
Yes,
Yes,
my
madam.
lord.
It
It
is
has been dismissed and disposed of
Yes,
by
madam.
order dated 17/6, my lord.
Okay. In WBC 112, then you say it is stated by the Learned Counsel for the parties that this matter has already been disposed of by an order dated
17/6.
17/6/2025.
Yes, madam.
Yes, my lord.
17/6/2025. Stop. Accordingly, this matter may not be listed along with the contempt petition.
Yes, madam.
Oblige.
Item 5.
Well, in item number 5, my lord, I am applying for respondent number 12, my lord. 12, my lord. In this case, my lord, I received the instruction, my lord. So I am allowed 3 weeks time, my lord, to file affidavit, my lord.
May I please, Your Lordship, I'm
Yes.
appearing on behalf of the petitioner. And in the last court date, it was in 27th June this year, okay, my lord. So, as per their convenience, today court was fixed. So they already took around 2 months for
Yes, my lord, on last
filing the affidavit in position. So if they keep on praying more time again and again,
my
I
lord,
think
last chance,
the
my lord, last chance, my lord.
parties pay no heed more. So I
Yeah,
think
this is a contempt petition.
Yes, ma'am.
Why are you taking so much
My lord,
time?
we are
Either
subsequently,
you comply or
no, we are
Yes.
subsequently implemented, my lord. Earlier, my
2 weeks. You file it within 2 weeks.
and matter will be on 21st I am coming, my lord. So 21st of November.
21st of November.
Yes, madam. In the meantime, I'll file, madam.
Learned Counsel, Mr. S.K. Mehdi, appearing for respondent number 12, prays for some more time to file his affidavit in opposition. Stop. The Learned Counsel for the petitioner, Mr. Such and such, has objected to the said prayer as the Learned Counsel for respondent number 12 had sought time even on 2/9/2025 and
It was the first time, my lord, after my filing Okalashnaama.
Okay. Stop. The court has considered the prayer of the Learned Counsel for respondent number 12, and it is seen that the respondent 12 had appeared for the first time before the court on 2/9/2025. In view of this, in view of the fact that the counsel for respondent number 12 has prayed for another 2 weeks, another 3 weeks as a last chance. Stop. The prayer is allowed. Stop. List the matter on 21/11/2025, before which date the learned counsel for respondent 12 shall file his affidavit and serve copies
Yes.
on the petitioner.
Yes.
Before that, you
Yes,
file and you
yes.
serve the copy also.
Yes,
Mr. Blood.
Items 6 to 11.
my lord, item is 6 to 10, my lord. I'm appearing for the railway, my lord. In this case, my lord, in principal bench, my lord, writ appeal is pending. Yesterday also I mentioned in the contempt matter, my lord. It was, my lord, listed on 23rd of this month, my lord. So I fixed this matter on today, my lord, on this October, my lord. This, my lord, due to time, my lord, it was not hard, my lord. So again, fixed my division bench, my lord. Code number 1, my lord, on my lord,
When?
4th of December, my lord.
4th of December.
So may I pray this matter will be, my lord, fixed on, my lord, 9th of December, my lord, after that case, my lord.
Your Worship, if I may,
Yes.
Your Worship, in the writ appeals which are pending before the principal seat, the question of payment under section 34 is involved. But in our matters, question of payment of interest under section 28 as well as 34 is
Yes, my lord,
involved.
both, my lord.
So my learned friend, if he's going to file any affidavit regarding the entitlement under section 28, they have not filed any affidavit till date, because that matter may kindly be looked into the next
my lord,
day.
I will file a affidavit, my lord, because so far 28 is
So,
concerned.
so regarding the payment under section 28.
Yes. Your Worship,
You have to file the affidavit.
Yes, my lord, yes.
Because that issue is not before the division.
that issue is not before the
My lord,
division bench.
yes, my lord.
Okay, read appeal number
Writ appeal, my lord, 265 of 23 and my 265
265 of 2023
and 320 of
and
23.
320 of
23, my lord.
2023. Learned counsel for the petitioner, Mr. A.R. Malhotra is present. For respondent, no, you are for the petitioner, right?
I'm for the
You are
petition.
for the petitioner, Mr. A.R. Malhotra is present. And the other advocates?
I am for the petitioner in item number 11.
Okay, just take down
Your
all
Worship,
the
I'm on
reflect.
item number 6, amigo. 6, 8 and 9.
Okay, 6, 8 and 9, and then 7, item number 7, then Ms. Sergeant Search for item number 10. Stop. And you are
I am for the petitioner in 11.
11 in item 11, okay. So, Learned counsel for the respondents number,
Lordship, I'm appearing on behalf of my senior Zairam Sangpui for respondent number 1
respondent
in
number
item
1.
number 6. In item number 7 for respondent number 1 and 2. And in item number 8 for respondent number 2. In item number 9 for respondent number 2. In item 10 for respondent number 2 and in item 11 for respondent number 2 and 3.
Okay, you take down, okay. That. Have you also filed your affidavit? Okay. Sergeant Search. And Ms. Sergeant Search also prays for some time to file her affidavit. Stop. Learned counsel for the respondent number, yours will be
I am for respondent 3, my lord.
3.
Yes, my lord, 6 to 10, my lord.
Respondent number,
Item was 6 to 10, my lord, I am appearing.
okay, in all the items, he's appearing for respondent number 3, okay?
Yes,
Mr.
all-
Yes, Mr. S.K.
6 to 10.
Medi. Mr. S.K. Medi appears and he submits that the 2 writ appeals being writ appeal number 265/2023 and writ appeal 320/2023 are pending before the division bench with regard to the same subject matter, and which has been filed against the directions passed by the single bench in WPC or different judgments, no?
Yes,
In the batch of writ petitions, which is in issue before this court in these contempt petitions. Stop. However, the learned counsels for the petitioners have submitted that the compensation under section 28 of the Act has not been challenged in the writ appeals, and therefore the respondent has to file the affidavit in response to the said issue. Stop. Respondent is
Only
therefore.
one thing, my lord.
Yes.
So for writ appeal number 320, my lord, or 23, my lord, in that case, my lord, this writ court, my lord, directed to pay 28 and 34, both, my lord, in the same order, my lord. But it is, that order also is suspended, my lord. So, but we are not the issue. That is not our issue, but it was state, my lord.
So whichever writ petitions 28 is involved, you file.
Yes, my lord.
Yes. So accordingly, what did I say? Last line. The, no, has not been challenged. Has not been challenged. 28 compensation under section 28 of the act is not been challenged, and therefore the respondents shall file their affidavits with regard to the said issue. Okay, stop. List the matters on 9th December.
9 December, my lord.
On 9th December 2025. 9th is okay.
Because that will also, ma'am, this time finish, my lord. That, 4th December, 4th December case is pending. Case is fixed on 4th December, my lord. So the 9th December.
Oh, 9th December 2025.
Christmas present.
Item 12.
My lord, this matter, will it be possible to fix it for another day, my lord? Because we have hearing today as well, my lord. Otherwise, it's ready for disposal.
Yes, ma'am.
Okay.
It can come up as a part 2 matter also, my lord.
December, my lord, fixed for hearing, my lord. Yes.
December.
Yes, ma'am. 5th of December, my lord.
5th of December, on the prayer of the Learned Council for the parties, list the matter on 5th of December for disposal. As admission hearing,
My lord, the pleading is complete, my lord. So matter will be fixed for hearing.
Part 2 also.
Part
admission hearing,
Part 2 hearing, my lord. Is,
part 2. It can be disposed of at the admission stage also.
yes, my lord. That is the.
Yes, it as admission hearing item. Yes. On 5th December, what did I say? 5th December.
Obliged, sir.
I'm for Union of India.
Yes.
My name is reflected. my lord.
Yes, Learned Council, put their names, okay? Learned Council for the petitioner, such and such, and SK Mehdi for the respondents.
Item 13.
My lord, we have filed a criminal petition, and
May it please, Your Lordship, I'm for respondent number 1 and I have already filed my counter affidavit. But since my senior, who is the leading counsel in this case, is on his legs in another court, if a date may be fixed for hearing.
Otherwise, objections also filed.
Yes, yes, my lord.
Okay, Learned Counsel for the petitioner, Miss Linda, such and such is present. Stop. Learned Advocate, Learned Counsel, MS such and such appears for the respondent number. You are for respondent
One.
number 1, and Mr. SK Mehdi, Learned Counsel, appears for respondent number 2. 2. Stop. The pleadings are complete. However, the leading counsel for the respondent number 1 is on legs in court number 1, and accordingly lists the matter for admission hearing when? On 5th December 2025.
Item 15.
Who's appearing in this case? PP? Oh, okay. You have received the case diary? Yes, on what grounds?
My lord, this is an application under section 483 of BNSS, read with Section 37 of NDNPS Act 1985. To enlarge the accused applicant on bail as he was arrested on 12/11/2024 in connection with SES case number 274 of 2024 under Section 21C of NDNPS Act 1985 by Excise and Narcotics, Serchhip District, Mizoram. My Lord, it is alleged that about 337.87 grams of heroin kept in 27 soap cases was recovered from a nylon bag found on the outskirts of Thenzo, which is allegedly linked to the applicant. It is pertinent to be noted that the alleged seized article was found near the roadside but not from the possession of none of the accused. My Lord, the accused already applied for bail application number 27 of 2025. But the circuit court, Serchhip, by its order dated 8/5/2025, rejected the application on the ground that it cannot be held that the accused is not guilty. Evidence is yet to be adduced, and if proved, the prosecution case may result in conviction. Balancing personal liberty with societal interest, bail was rejected, my Lord. And my Lord, on perusal of the charge sheet, it is found that the alleged recovery is not from the conscious possession of the applicant, but from outskirts of Thenzo. And the alleged ownership of the bag is based on suspicion and circumstantial evidence. Corresponding, the seizing officer received information from Thenzo Joint YMA. However, the seizing officer did not reduce the information in writing that violated the provisions of NDNPS Act 1985, which is mandatory under the Act. It is, my Lord, pertinent to mention that there are material lapses in the seizure, sampling, inventory, and forwarding procedure, and therefore, the very foundation of the prosecution case is doubtful. My Lord, if that on perusal of the complaint sheet, the seizing officer did not mark nor number the essay. Furthermore, the seizure procedure was not carried out in compliance with the NDNPS Rules 2022. The investigation officer mentioned that all the essays were bunched in 3 groups. Each bunch contained 9 soap cases, but without showing identical size, weight, or marking as mandated under Rule 10 of NDNPS 2022, the inventory and photographs do not reflect the 27 soap cases of the bunching thereof. My Lord, instead of only sampling marked as 1, 2, and 3 are shown, while in the list of samples they are marked differently. Furthermore, my Lord, the weight of only one sample, that is 5.61 grams, is mentioned, while others are not reflected in the inventory. My Lord, if I may take you to the page number 29, my Lord. Here we can see that, my Lord, this is the report number FSL, which has been forwarded to Chief Judicial Magistrate.
What is this? FSL report.
Yes, my Lord.
Yes.
My Lord, in the FSL report, in the exhibit, there is 3 exhibits, and the samples were drawn, and it was weighed about 4.5 gram, and the sample number 2 is 4.4 gram, number 3 is 5.0 gram. But my Lord, in any forwarding, there is nothing to be found that how much gram was being sent to the FSL.
No, but they have received 3 exhibits. That means the FSL has received 3 exhibits.
Yes, my Lord.
Yes. So you mean to say more than 3 packets were recovered? How many packets were recovered?
27 soaps, my lord.
27 soaps. Do not reflect the 27 soap cases.
And my lord, if we look into the FSL report being sent to the CJM, here, my lord, at the first paragraph, at the end, it is written 21B of NDNPS Act 85, while the charge section was 21C of
21C.
NDNPS Act. My lord, there are unexplained delay in forwarding the samples for the to the forensic science laboratory. The samples were drawn on 3/11/2024, but dispatched only on 5/11/2024. Received by FSL on 19/11/2024, and the report was forwarded on 19/12/2024. Such delay of over 15 days casts doubts on the integrity and tamper-proof nature of the samples. Moreover, the FSL report shows variation in weights of 3 samples, that is, which I have mentioned, my lord, 5.0 grams, 4.5 grams, and 4.4 grams, further creating serious doubt regarding the reliability of the prosecution case. My lord, that the number of the CIS Article 27 cases was not done in the presence of independent search witness as required under the NDNPS Seizure, Storage, Sampling and Disposal Rules 2022.
No independent witnesses.
Yes, my lord.
Where is the seizure memo?
My lord, on page, 1 second, my lord. My lord, 22A. The lordship has it, my lord.
22A, yes.
My lord, if
Witness.
the retype copy of page number 22A is in page number 22B, my lord, the next page.
Okay, these 2 witnesses are police personnel.
Yes, I believe so, my lord. No, my lord, no. They are not. They are civilian.
Then
My lord, if I may read out this particular point.
Yes.
The CIS article, 337.87 grams of yellowish powder suspected to be heroin, kept in 3 white, 1 red, 11 blue, and 12 green color soap cases wrapped in a white nylon sack. My lord, there is no there's no reflection of 27 soaps herein. So there is a contradiction in the custody, in the chain of custody, my lord. There is a serious doubt.
You mean there is a contradiction in the description
Yes, my lord.
of the CIS article?
Of the CIS article, my lord. Even though it and my lord.
In the FIR, they have said 27 soap cases.
Yes, my lord.
Yes, Your Lordship, if I may.
Yes.
Even though here it is not written 27 soap cases, but altogether it is 27. The thing is that they have written separately the color of the soap case. Three white soap
Three
cases
white,
is there,
one red,
soap cases, 11 blue soap cases, and 12 green color
12
soap
green
cases.
colored.
So altogether it is 27.
My lord, as per the rules and the mandatory law, it has to be mentioned specifically, my lord. My Lord, it is also humbly submitted that the original search and seizure took place on 2/11/2024, as indicated in the case records. And seizure memo, however, the charge sheet bears the case number dated 3/11/2024, creating a discrepancy in the timeline of filing. The discrepancy raises a doubt about compliance with the procedure timelines mandated by law for filing charge sheet. My Lord, such lapses cast serious doubt on the authenticity and bona fides of the prosecution. My Lord, the prosecution burden to prove strict procedural regularity has not been discharged beyond reasonable doubt. My Lord, if I may take you to page number 24B. That is the English translation of page number 24A. It is the statement of the accused Gospel Larotfela. My Lord, if I may read out.
Yes.
My name is Gospel Larotfela. My father's name is Ramding Liana. I am presently residing at Tenzol, Wenglun with my family. On the 9th of 2/11/2024 at around 10:30 p.m., Tenzol joined YMA duty and excise. Duty personnel came to my house and told me that on the way to Aizawl, right before Tong Taina, on the embankment, that is at the outskirt, my Lord, they found certain amount of number 4 and suspected that it belonged to me, and they took me to the place. Excise duty seized the number 4, which was in total of 27 hong. They weighed and packed the seized article, which as a whole was 337.87 grams. They also immediately arrested me. The number 4 which they seized was transported from Champhai, which was to be handed to VAI, that is non-BIZO personnel. And I only helped to store it just because I am continuous user of number 4. And I am being arrested. I have also been arrested before because of number 4. My Lord, here at the deposition of this gospel of the accused, it clearly says that I am being arrested. So he was not informed on the grounds and reasons of arrest by the excise personnel, my Lord. And to support this submission, my Lord, I have an authority by this coordinated court, my Lord. If I'm My Lord, if I may take you to page number 12.
Yes.
If I may read out, my Lord, para number 15. The Apex Court also held that there is a significant difference in the phrases reason for arrest and grounds of arrest. The reason for arrest, as indicated in the arrest memo, are purely formal parameters and for preventing the accused person from committing any further offense for proper investigation of the offense, for prevention of the arrested accused person from causing any disappearance or tampering with the evidence, etc. The grounds of arrest, on the other hand, will require to contain all such details in the hand of the investigating officer which necessitated the arrest of the accused. Simultaneously, the ground of arrest informed in writing must convey to the arrested accused all basic facts on which he was being arrested, as to provide him an opportunity of defending himself against custodial remand and to seek bail. Therefore, the grounds of arrest would be personal to the accused and cannot be equated with the reasons of arrest, which are general in nature. Paragraph number 26 to 30 of the said judgment, which are relevant for the consideration of the present case, may be abstracted here and there for ready perusal. My Lord, I will take you to page number 13. The relevant point is on page number 29. My Lord, if I may read out. Hence, we have no hesitation in reiterating that the requirement to communicate the grounds of arrest on the grounds of detention in writing to a person arrested in connection with an offense or a person placed under preventive detention as provided under Article 22 Clause 1 and 22 Clause 5 of the Constitution of India is sacrosanct and cannot be breached under any situation. Non-compliance of this constitutional requirement and statutory mandate would lead to the custody or the detention being rendered illegal as the case may be.
Yes, that Vihan Kumar case is also there. Vihan Kumar,
Yes, my lord.
Purkayasta. But for that, we have to see the records.
And my lord, there is another point where I would like to take your attention to is at page 42.
Page 40,
2, my lord.
42 of your petition.
Yes, my lord, of the petition.
Yes.
Yes, my lord. If I may read out that
Yes.
there is,
Authorization.
yes, this is, my lord, the authorization under section 41 clause 2 of the NDNPS Act. My lord, here, as we can see, there is a blank space where it should be filled as per the rules and the, as the law, my lord. Here, it has been left blank, whereas it should be recorded specifically the premises, the place, the time, and where to search, my lord. This is the authorization, my lord. And the absence of such specification amounts to non-application of mind and indicates the authorization. My lord, there is a clear recorded reason to believe that there is a lack of precise specification of search place which contravenes mandatory procedure safeguards. And the absence of these mandatory details reflect non-application of mind and procedure non-appliance, vitiating the entire seizure and search operation under Chapter 5A NDNPS Act, my lord. And to support my submission regarding this, my lord, I have the State of Punjab, Balbir Singh, 1994, Volume 3, SCC 299. My lord, if I may take you to page number 321.
Yes.
Your lordship has it?
Yes, 321.
Yes, my lord. Next to Placenta D, my lord.
D.
D, yes, my lord. If I may read out, my lord.
Yes.
Under section 41 clause 2, only the empowered officer can give the authorization to his subordinate officer to carry out the arrest of a person or search as mentioned therein, my lord. If there is contravention that would affect the prosecution case and vitiate the conviction, my lord. Here it clearly states that there should be mentioning of the specific place, time, and so on, my lord.
No, here it only says that.
My lord, I will
that the
further read
empowered
out, my lord.
officer- yes.
Under section 42 clause 1, the empowered officer, it has a prior information given by any person that should necessarily be taken down in writing. But if he has reason to believe from person knowledge that offense under chapter 4 have been committed or materials which may furnish evidence of commission of such offense are concealed in any building, etc., he may carry out the arrest or search without a warrant between sunrise and sunset, and this provision does not mandate that he should record his reasons of belief. But under the provisions of proviso to section 42 clause 1 of such, if such officer has to carry out such search between sunset and sunrise, he must record the grounds of his belief. My Lord, and according to the prosecution case, is found mentally flawed and the evidence obtained is inadmissible, requiring dismissal of charges and or acquittal of the accused, my Lord. And my Lord, here in the perusal of the charge sheet, my Lord, if you look into the samples, there is, as I have mentioned, there is a charge section which was written as 21B, whereas in the charge sheet it is written as 21C as well. And there are discrepancies in the custody, in the chain of custody of the samples, my Lord, as well as the procedures, and with the arrest, my Lord. And
It's 21B or 21C?
it's 21C, my Lord.
C. Because in the charge sheet, they have written 21B.
Yes.
Okay. On top it is prima facie case under 21C, then towards the bottom again 21B. But the quantity is commercial, so it will be 21C.
The quantity is commercial, my Lord.
Yes. Then what else?
My Lord, there is a benefit of doubt in regards, in favor of the accused, wherein there are two views. And in the cases of Dilip and another, my Lord, I would like to rely on this authority, that is 2007 Volume 1, SCC 450. Dilip and another, State of MP. My Lord, in page number 452. Here, my Lord, it is mentioned that the principles which is clearly written, if I may read out, my Lord.
Yes.
It is now well settled that the offence committed under the Act is a grave one. Procedural safeguards provided thereof. Therefore, in terms of Section 41, 42, and 50 of the NDNPS Act should be complied with. Here, my Lord, it is mandatory to comply with the Section 42, 41, and 50 of the NDNPS Act, my Lord.
Trial has started.
Yes, my Lord. My Lord, it is also mentioned in the state of 2011, Volume 1 SCC 784, State of Kerala versus Ranif, that in bail in absence of prima facie, that it is written, it is reflected in deciding bail application. An important factor which should certainly be taken into consideration by the court is the delay in concluding the trial. Often this takes several years, and if the accused is denied bail but is ultimately acquitted, who will restore so many years of his life spent in custody is custody. Is Article 21 of the Constitution, which is the most basic of all the fundamental rights in our Constitution, not violated in such a case? Of course, this is not the only factor, but it is certainly one of the important factors in deciding whether to grant bail. In the present case, the respondent has already spent 66 days in the custody as stated in paragraph 2 of this counter affidavit, and we see no reason why he should be denied bail. A doctor incarcerated for a long period may end up like Dr. Manet in Charles Dickens' novel A Tale of Two Cities, who forgot his profession and even his name in the Bastille.
Yes, let us see the case diary. When the trial takes a long time, say 5, 6, 7 years, then usually even if it's commercial
My lord,
quantity,
he has been,
courts are inclined to allow in
Yes,
view
my
of
lord.
the delay. But in this case, it's only
he's been
been
in the
1
custody,
year.
my lord, for 11 months, 26 days, almost 1 year. And that, my lord, the charge sheet was filed on 23/12/2024. That is all, my lord.
Yes, Your Lordship.
Yes.
During trial, 2 witnesses have been examined. One is the civilian witness, and another one is the case IO. So out of 6 witnesses, now 2 witnesses have already been examined.
Only 4 left.
Only 4 left. And it can be seen the trial is going on. And regarding the conscious possession, Your Lordship, what I would like to mention here is that from the statement which the appellant himself has read out, it can be seen that he has conscious possession. He admitted that he helped him to hit that number 4, heroin. So that means he has conscious possession. And once there is a conscious possession, the statutory presumption arises, which the appellant had to prove himself during trial. And now trial is started, and it is the appellant who has to explain that he do not have any conscious possession of the seized contraband. And Your Lordship, another thing is that from
Excuse me, give me the NDPS Act. NDPS Act. It's here, it's here. Yes, and then?
Yes, Your Lordship, from the statement of the case IO, it is seen that during daytime, the appellant was there
Arrested.
in that place, which was seen by the local NGO, YMA. So due to that, he was suspected. And moreover, he is a habitual offender. And after arresting him, he himself admitted that he helped them to hit that contraband. Even though there is no physical possession, it doesn't mean that there is no conscious possession. Conscious possession means
Knowingly he has kept it there.
yes, knowingly he kept it, he hid it there. And Your Lordship, regarding the now section 42, which the appellant has stated, Your Lordship, here as we can see that the recovery was in the public roadside. So section 42 does not arise, and there cannot be a strictly compliance of section 42. That is in a public place. And another thing is that since the applicant is a habitual offender, Your Lordship, if he is released on bail at this stage, there is a high chance of absconding and also to commit the same offense. And another thing which the appellant has mentioned, I believe that he mentioned about section 50 in the DPS Act. Your Lordship, after going through this record, it can be seen that there is no personal search. And if there is no personal search, there is no reason of compliance of section 50 in DPS Act. Since section 50 in DPS contemplates with personal search. And regarding the FSL report and all, Your Lordship, that is the thing which have to be proved during trial. And after examining the witnesses, it can be seen that whether they have disputed against the purity of the heroine number 4. So that has to be looked during trial. And now we are in the matter of bail, so the merits of the case cannot go into. What we have to look during this bail is what is the ground which the accused has to be released on bail. And the appellant did not serve any good grounds that he has to be released on bail. And in this regard, Your Lordship, my submission is not to release the accused on bail at this stage, since he is the habitual offender, and from the statement, from his statement himself, it can be seen that he has conscious possession, and conscious possession is one of the requisite content in the NDPS Act, and conviction can be based solely on the conscious possession. So my humble submission is to reject this bail application at this stage.
Who is PW2?
PW number 2 is the one of the civilian witnesses.
Okay.
And even during cross-examination, they did not rebut anything regarding the conscious possession, that he was present before seizing that contraband.
My Lord, if I may make
Yes.
another, just 2 more points of submission, my Lord. My Lord, it is, the learned friend have mentioned that there is
No,
another.
see, trial has already started.
Yes, my Lord.
And out of 6 witnesses, 2 already examined. So 4 will give a direction to expedite the trial, that's all.
There is, my Lord,
Yes,
if I,
only
if-
4 left.
my Lord,
Yes.
I will just make another 2,
Yes.
3 points of
Yes.
submission. My Lord, it is
No,
true
this
that,
court is not inclined to interfere at this stage. Yes, anyway.
my Lord,
yes.
it is true that some cases are pending, but no conviction has been recorded yet.
No, we won't go into that
Yes,
other
So,
cases.
and there is another point, my Lord, in the admissibility of the confession statement of the accused, recorded under Section 67 of the NDNPS Act, which is also laid in the Tufan Singh versus State of Tamil Nadu, SCC, my Lord. So it was laid down that such confessional statements are not admissible in evidence, my Lord.
No, the court is just looking at the PW statement also, evidence also.
So,
There
my Lord,
the
there is no
independent
conscious,
witness- yes.
it was not in the contraband was not seized from
This is
the,
what the independent witness has said. The accused, such and such, told the excise duty that the hidden nylon bag belongs to him.
so there is no proof as to which it belongs to him or not, my Lord. There is no such proof, there is no evidence in regards to that, my Lord. There is no single transaction, no phone
No,
call
but
records.
confessional statement, it can be, it's not a substantive evidence, but it can be used to corroborate the other evidence. So that is corroborated by the PW2. Because the PW2 was there when you told the excise duty personnel that the bag belongs to you. Okay.
My Lord, there is
Yes.
another submission which I would like to make, that the accused, he is the permanent resident of Tenzol, and there is no chance of absconding if bail is granted, and if it is,
See, section 37 NTPS, okay, in respect of
yes, my Lord.
commercial quantity, where there are reasonable grounds for believing that he is not guilty of such offense, that is another thing. Then the second part is he is not likely to commit any offense while on bail. So even if you are a resident of Aizawl and there is no chances of absconding, but what about this, that he is not likely to commit any offense while on bail? So that the court has to satisfy, looking at all the facts and circumstances, isn't it? So even in the rejection order, I think that was taken into consideration. Where is the rejection order? Have you enclosed?
Yes, my Lord.
The trial court's rejection order, page?
Page 15, my Lord.
In para 8, Your Lordship, it is clearly mentioned.
No, the
The
reason
rigor
is
of
given to it is
Section 37 applies.
further the liberty in cases where this is rejected. Yes, further the liberty of a citizen has to be balanced with the interest of the society, and in cases where NDPS is involved, accused would indulge in activities which are lethal to the society. So on the same grounds that has been rejected. Yes. Okay, right. Yes, anything else?
Yes, my lord. If I may take you to lastly,
Yes.
21B, my lord. That is
I appreciate your persistence. Yes,
Thank you, my
21B.
lord. Yes, this is the report of seizure and arrest, my lord. Earlier, I have made submission in regarding to Article 22, Clause 4, my lord. So, if I can make some corroboration with this, my lord, if I may read out.
Yes.
I have the honor to repeat that report that on 2/11/2024 at 11:30 p.m. near Tongtainamhun, Tenzo seized such and such of yellowish powder suspected to be heroin kept in 27 cases, 3 white, 1 red, 11 blue, and 12 green colored, wrapped in a white nylon sack, and also arrested the possessor, Gospel Rotfella 30th, son of Ramding Liana, Tenzol, Wenglun, at the same time, place and date in presence of civilian witnesses. The ground of arrest was intimated to the accused mother on the spot. Here, my lord, report of seizure and arrest. There is no mentioning of informing the reason and grounds of arrest to the accused, my lord. Only the intimation was given to the accused mother on the spot.
What about the FIR? In the FIR, what does it say? And then arrest memo. Achha, this is one aspect, okay, because even in the record, I have not found that the grounds of arrest have been supplied to the accused.
Yes, Lordship, if I may, in that regard.
Yes.
Now, belatedly, he had raised that Article 22(1). So, in that regard, Your Lordship, if we look into the citation which you have mentioned, Bihan Kumar, in that Bihan Kumar, what the learned Supreme Court, the Honorable Supreme Court, means to express is that the accused, the arrested person has to know his grounds of arrest. But in this present case, he knows his grounds of arrest. He himself has stated that the seized contraband of heroin was seized. So he knows his grounds of arrest. Moreover, he already mentioned that he has been arrested more than one time for the same offense. And regarding he knows that he have to engage the lawyer, and he already
My lord.
applied for counsel also. So he is aware of his right. So Article 22(1) is to make him aware, to make the arrestee person, to make him aware of his grounds of arrest, as well as he has the right to engage a lawyer. So he knows all that things, and verbally he was informed, and that has to be proved, whether that grounds have been informed him or not. That has to be proved.
No. Even in the records, in the case diary, that ground of arrest with the signature of the accused, that should be kept on record.
Yes.
Here in page 22A, seizure and arrest memo, Your Lordship.
Where is that?
22A of the bail application.
32A.
22A.
22A.
Here on the bottom, he put his signature, Gospel Lalwatfela accused.
My lord,
And here it is mentioning that the says article were written down. So he was informed.
there is no recording as to such. He was informed, or he was informed, my lord. Non-compliance to this constitutional requirement and statutory
There is
mandate.
a slight difference in this case because you yourself showed the bag where it was kept. So which means that the knowledge was there. Okay, right. This application under section 483 of the BNSS has been filed. Who's the petitioner? Accused himself.
My lord?
The accused himself has filed the petition.
No, my lord.
Who has filed on his behalf?
On his behalf, Arlal Hunsiyama, my lord.
No. The accused is this gospel, isn't it?
Yes, my lord.
So he himself has filed, that means. Yes. Under 483 of BNSS, by the accused applicant praying for release on bail pending trial of SES case number 274 of 2024 pending before the learned special judge NDPS Serchip SERCHHIP. Stop. Para heard learned counsel for the petitioner / applicant Mr.
J.H. Ricky Lalwatfela.
Such. Stop. Also heard Ms. Vani Siami, learned PP for the state of Mizoram. Stop. Para. The grounds put forward by the petitioner in the present application are as follows. Dash. Number 1. The accused applicant was arrested on 2/11/2024 for alleged possession of 27 soap cases containing heroin. Stop. However, it is stated that there are several procedural lapses during the search and seizure, as well as sampling and marking in the samples. Para. Learned Counsel has submitted that. This is number 2, okay, ground number 2. Learned Counsel has submitted that the investigating officer has not shown has not sent the samples of all the 27 soap cases, and instead the samples are only marked as 1, 2 and 3. And further, the weight of only one sample is mentioned, while others are not reflected in the inventory. Stop. Number 3. there was unexplained delay in forwarding the samples to the FSL. Stop. The samples were drawn on 3/11/2024 but dispatched only on 5/11/2024, received by the FSL on 19/11/2024 and report forwarded on 19/12/2024. Stop. Such a delay of over 15 days casts a doubt on the integrity of the samples. Stop. Moreover, the FSL report shows variation in the weights of the three samples, i.e. 5 grams, 4.5 grams and 4.4 grams, creating further doubts regarding the reliability of these samples. Stop. Next number. The Learned Counsel has also submitted that the grounds of arrest has not been provided to him. As required under the law, and in violation of Article 22(1) of the Constitution of India. Stop. Next number. Another ground taken by the Learned Counsel is that in the authorization, where is that authorization letter?
Page 47, my lord. 42, my lord.
42. In the authorization letter issued to the seizing officer, the description of the premises and the area in which search is to be conducted has not been mentioned, and the blank and the portion where the same is supposed to be inserted is kept blank. Stop. Therefore, this also goes to show that there is a contravention of section 41 of the NTPS Act. Stop. Next number. Learned Counsel further submits that the Assistant Director of FSL, while forwarding the FSL report, white letter dated 19 December 2024, has mentioned the section as section 21 small b under small b of NDPS Act instead of 21C of the NDPS Act. Stop. Even in the charge sheet, the IO has mentioned Section 21C of the NTPS Act as well as, oh sorry, he is referring to the other cases where you were booked. Just delete that part. We delete that part about the charge sheet, okay? Stop. Learned Counsel. Okay, then you start a new paragraph. Regarding the grounds, that's the end, a new paragraph. Learned Counsel has relied on the case of 1994. State of Punjab versus Balbir Singh, reported in 1994, 3 SCC 299. To support his contention that Balbir Singh was on which point?
Page 321, my lord.
321. Okay. To support his submission that only the empowered officer can give authorization to his subordinate officer to carry out the arrest of a person under Section 41(2) of the NTPS Act. And if there is a contravention that would affect the prosecution case and vitiate the conviction. Stop. The Supreme Court also stated that under the proviso to Section 42(1), if such officer has to carry out such search, such officer has to carry out such search between sunrise and sunset. Between sunrise and sunset. Stop. And if such search is carried out between, if such search is carried out, but under the provision carried out after the said period, comma, he has to record the grounds of his belief. Stop. Learned Counsel also relies on the case of Dilip, D-I-L-I-P, Dilip and another versus State of MP, reported in 2007, 1 SCC 450, wherein the Supreme Court held that the offence committed under the NTPS Act is a grave one, and procedural safeguards provided in terms of Section 41, 42 and 50 of the NTPS Act should be complied with. Stop. In view of the submissions as stated herein above, Learned Counsel submits that Learned Counsel prays that the accused herein may be released on bail pending trial, pending completion of the trial. Stop. He has also submitted that the accused has now been in custody for 1 year.
11 months, 26 days.
For 11 months, 26 days till date. Stop. para. Learned Public Prosecutor M.S. Vanisyami has appeared for the state respondents and submits that there are two independent witnesses in the present case regarding the seizure of the seized articles. Stop. Moreover, it was the accused himself who had shown the seized article to the excise personnel. Stop. Therefore, there was conscious possession on the part of the accused. Stop. Learned PP has also submitted that in the present case, the accused was very well aware about the grounds of arrest, as he was the one who had showed the seized article to the police personnel, and he knew that the same was a contraband substance, and therefore the constitutional safeguard of Article 22(1) of the Constitution has been complied with. Stop. In the report of seizure and arrest dated 3/11/2024, it is clearly stated that the ground of arrest was intimated to the mother of the accused, and the accused has put his signature therein. Stop. Learned PP also further submits that the recovery was made on a public road, and therefore the compliance of Section 42 NDPS Act does not apply strictly in the present case. She has also submitted that there is no that this is not a case of personal search, and therefore Section 50 of the NDPS Act is also not applicable. Stop. As far as the submissions of the applicant regarding the FSL report and the sampling is concerned, the same can be proved or rebutted only after evidence is adduced and not at this stage. Stop. Learned PP has also submitted that the trial has not been delayed, and in fact, out of 6 prosecution witnesses, 2 PWs have already been examined, and only 4 PWs are to be examined. Stop. Therefore, the question of delay in trial is also not relevant in the present case. Stop. learned BP therefore prays that the present petition may be dismissed. Stop. Para. This court has considered the submission of the opposing parties and has perused the application, the pleadings as well as the trial court records. Stop. The present case pertains to the seizure of contraband items which are which are of commercial quantity. Stop. In such cases, the rigors of RIGORS, the rigors of Section 37 of the NTPS Act is to be applied, wherein it is held that, wherein it is stated that the court has to be satisfied that there are reasonable grounds for believing that the accused is not guilty of the offense and that he is not likely to commit any offense while on bail. Stop. In the present case, it is seen that a prima facie case has been established against the accused appellant, and the most relevant is that the trial has already started and 2 BWs out of 6 has already been examined, which means that the trial is being conducted on time. Stop. In such a case, this court is not allowed, is not inclined to allow the present petition and is accordingly dismissed. Stop. However, it is directed that the learned trial court shall complete the trial as expeditiously as possible. Stop. Petition application disposed.
Obliged, my lord.
Item 18.
This one you return it to the BP, okay?
May it please your lordship?
Yes.
This is an implement application for the implement of a new incumbent to the post of the Chief Engineer Highways, my lord.
Oh, okay. In the contempt case.
Yes, my lord, in the contempt case.
This application under Order 1 Rule 10 read with Section 151 CPC has been filed praying for implement of the new incumbent Shri Robin Lalrinwama, LALRINAWMA, the new Chief Engineer, PWD Highways, Aizawl, Mizoram, as respondent number 16. Stop. Para. Heard learned counsel for the petitioner, Ms. Such and such. Stop. It is stated that the applicant petitioner has filed the connected contempt petition number 12 of 2023, alleging willful disobedience of the order dated 17/8/2022, passed in WPC 128 of 2021. Stop. Para. It is stated that during the pendency of the said contempt case number 12 of 2023, the post of Chief Engineer Highways, PWD, Government of Mizoram, has been taken over by the new incumbent, Shri Robin, such and such. You just see from the petition, okay? Shri Robin, such and such. Stop. Due to the above situation, it has now become necessary to implead the new incumbent as respondent number 16 in the connected contempt petition. Stop. Hence, the present application has been preferred. Stop. Para. Upon considering the prayer of the learned counsel and the pleadings in the application, stop. The petition is allowed. Stop. The applicant is allowed to file the amended cause title impleading the new respondent as respondent number 16 in the contempt case number 12 of 2023, and thereafter serve notice on the newly impleted respondent number 16 by registered post as well as usual process within 3 working days. Stop. List the case after 2 weeks. List the case after 2 weeks.
Item 19.
Acha, yes. Any instruction?
Your Lordship, yes, I talked to both the appellant here in Malur. I'm sorry to say that they are not interested in.
They are not inclined.
Interested in settlement matter outside.
Okay. We continue with the hearing then.
My lord, I will start
Yes.
from the beginning because I think on the last occasion, if I've not mistaken, my lord, we had not gone into the records of the case thoroughly, my lord. So perhaps, my lord, because the matter is actually quite small, the plaint is also like, I think around just 3 pages, my lord. So I will go through all of them. And then from there on, my lord, I will try to provide to your lordship the submissions that I will have in reply to my learned friend, my lord. If
But
your lord,
first of all, you have to overcome that absence of a written statement, isn't it?
no, there is a written. I'll do that, my lord. In the process, my lord, I will take your lordship through the submissions.
Okay.
Now, my lord, page 1 of the paper book, my lord.
You can leave.
That is the plaint.
Yes.
Now, my lord, I will read from the first paragraph. That the plaintiff is a bona fide citizen of India, belonging to the scheduled tribe community of Mizo, and is a permanent resident of the suit land covered under LSC number 103-702-01-1006 of 2006, located at Zonuam, Aizawl, and as such he is entitled to all the rights, privileges and protections available under the Constitution of India and other laws made thereunder. That the plaintiff is the legal and rightful owner of a plot of land covered under LSC number so-and-so, located at Zonuam, Aizawl. He has been paying taxes regularly till date, and he is peacefully occupying the said site ever since 1996 without any disturbance. That, however, sometime back in 2003, the defendant boldly and on the instigation of some of the then local authority had wrongly begun building on a some type house. Now, my lord, I will just stop here, my lord, and tell your lordship that my learned friend's client, my lord, he had retracted from his plaint in his examination in chief. So just keep that in mind, my lord. He has changed his statement. That, however, sometime back in 2003, the defendant boldly and on the instigation of some of the then local authorities had wrongly begun building on a some type house on the upper side of the plaintiff's landed property adjacent to the jeepable road without his permission and consent. He then submit complaint to the Land Revenue and Settlement Department, Government of Mizoram, and the pro forma defendant in response to the complaint of the plaintiff. And also, my lord, let me just stop your lordship again one more time, because I think we should understand the sequence. The LSC was issued in 2006, because the LSC was of 2006. The house was built in 2003. As is written here. So the sequence as portrayed in the plaint, my lord, is not completely accurate. because he's trying to portray himself as the LSC holder during that time. Anyway, my lord, let me continue, my lord. He then submit complaint to the Land Revenue and Settlement Department, Government of Mizoram, and a pro forma defendant. In response to the complaint of the plaintiff, issued order dated 10/6/2008, detailing Pu Lal Kaubika, surveyor, and Pu Vanlal Ngaya, chairman, to conduct spot inquiry on 18/6/2008. However, none of the detailed officials of the pro forma defendant reached the spot on the appointed date to conduct spot verification. My lord, this is again inaccurate. We will see from the record. They all reached the place. As the pro forma defendant failed to take concrete steps to redress the grievances of the plaintiff, he then submitted another complaint again to the pro forma defendant, praying to settle the boundaries of the plaintiff's land and to duly evict the defendant from the landed property of the plaintiff. And in response to which the said pro forma defendant again issued order detailing their staff, namely Pu Lalbia Kluang Aparte, to carry out the measurement of the plaintiff's land on 26/8/2008, via order dated 14/8/2008. This is also wrong, my lord. This sequencing is wrong. This time, the detailed officials actually reached the plaintiff's land and conducted measurement of the land. However, no outcome or positive result was seen even after the said spot verification, and no material step has been taken by the pro forma defendant till date, and hence having no other option, the plaintiff filed the instant suit. Now, the cause of action first arose in favor of the plaintiff in 2003, when the defendant illegally built house on the suit land belonging to the plaintiff, and it arose afresh again in August 2008, when the pro forma defendant failed to take necessary steps for eviction to the defendant even after spot verification, and continues till date until and unless the defendant completely vacate the suit land and leaving it to the peaceful possession of the plaintiff. That this honorable court has both the pecuniary and territorial jurisdiction to adjudicate upon the present suit. My lord, I'll not read all of those things, but if your lordship will come to the document they had submitted. The first is the LSC copy, which is at page number 5, my lord. I will not go there, but if your lordship will come to page number 11. Now, this was a document the plaintiffs themselves submitted, my lord. It says like this. Mr. F. Vanal Shuaya owns LSC number so-and-so at Zone 1 locality. Mr. Lal Kaubika, surveyor, and Mr. Lal Ngaya, chairman, are detailed to demarcate his land on 18/6/2008. Mr. F. Vanal Shuaya and his neighboring landowner, my lord, this is important, neighboring landowner, my lord. The Revenue Department accepts the ownership. Owner, Mr. Vanal Ruata, are hereby instructed to be present on the spot with their respective passes on this day. This is important. And on the next page, my lord, this is after 2 months. So incidents, things happened, my lord. Things actually happened, and the additional documents I submitted, my lord, will give your lordship, will throw some lights on that. Now, page number 12, my lord, this is an order. This is not even an office noting. This is an order. Mr. Lalbia Kluang Aparte is directed to demarcate Mr. F. Vanal Shuai LSC located at Zone 1. He is also to demarcate the land of Mr. T. Vanal Ruata, that is my client. And also prepare NOC. NOC, my lord, means no objection certificate. NOC along with all other required documents. So he is supposed to prepare the NOC, means, my lord, no objection certificate along with all the other required documents. Now, all the required documents are what we submitted before this court, my lord. These were not submitted by my learned friend. They should have submitted because they were the plaintiffs. They were hiding facts, my lord.
But
now,
these are part of the plaintiff, but this one?
This was part of the plaintiff.
Part of page 10, 11?
Correct. Yes. These were their annexures, my lord. These were their annexure number 2 and their annexure number 3.
Yes.
And they had exhibited them themselves, my lord, exhibit P3 and exhibit P4. Now, my lord, the written statement that we had submitted was handwritten by the defendant then. My lord, this kind of defendants who have legal aid counsels and who we appear on pro bono, my lord, these poor people, they usually do, sometimes they start their cases like this, my lord. And in this case also it started, and during those days, my lord, in Mizoram, because of section 21 of the Civil Courts Act, my lord. Section 21 Civil Courts Act, my lord, says like this. I'll quickly read, my lord, your lordship does not even have to turn the page. It says like this: subject to the provisions contained in subsection 3 of section 1 of the Code of Civil Procedure 1908, The procedures prescribed in the code shall, so far as is otherwise provided by this Act, be followed in spirit, my lord, not in letter and spirit, in spirit in all the civil courts. Now, because of this reason, my lord, this is section 21 of the Civil Courts Act.
Section 21,
Correct, my lord.
Mizoram Civil Courts
Mizoram
Act.
Civil Courts Act. This was Mizoram Civil
Mizoram
Courts
Civil
Act.
Courts Act, which
is
year?
Yes, my lord. Mizoram Civil Courts Act 2005.
2005. Okay.
Now, because of this, my lord, the court had also accepted this written statement he had submitted without any demur. In fact, the defendant also did not raise any objection. Issues were not raised in this respect, my lord, in the lower court. There was no objection at that time. So it was accepted by the lower court. In fact, my lord, it was for the first time that he had raised this objection in this court. Anyway, my lord, page number 7, this was provided to us. I'll read it, my lord.
Yes.
My lord, it was provided in a newspaper, my lord.
In the court's copy, it is given as page 13A.
Okay, my lord.
In the paper book.
Yes.
Yes, you can read it.
Yes. As per your letter number 91, Senior CSRCJ so-and-so, I am writing to uphold and preserve my rights and entitlement. After I left Remnaroon home in 1986, my lord, Remnaroon home would mean refugee place, where all the people who have been affected by refugees, the insurgency, my lord, they still have that place, Remnaroon.
Okay.
After I left Remnaroon home in 1986, I reside at Zonwam locality with my wife and children. During 1994, the village council leaders of Zonwam decide to arrange for allotment of land at Berampumwal area to the poor residents of the locality who do not own their own land. I was assigned plot number Z in the process, and I also have attached a sketch map. This was also exhibited. The sketch map is exhibited, my lord. In order to ensure easy allocation of parts by the revenue department, those that were able decided to build a house in the land allocated to them. The YMA2 decided to build a house for Mr. F. Vanalswai, that is the plaintiff, in this regard. As for me, I took an LIC and started my construction in 2002, and I occupied the house the same year. My land was measured in the year 2003 for preparation of LSE. And as I was not present, my land was demarcated and included in the land of Mr. F. Vanalswaya. An LSC was thus issued in the year 2006. So 2003 it was demarcated, 2006 it was issued. I then realized soon after that my land was covered in someone else's LSC. I was deeply worried, and I decided to approach the then Revenue Department Minister. I informed him of all my problems, and when I told him about the details, he took pity on me and he drafted a letter for me, which I submitted to the Assistant Director of Survey T. He ordered for the original LSC of Mr. F. Vanalswaya to be submitted to him. My lord, the records will show you that this LSC also was submitted by Mr. F. Vanalswaya. Mr. F. Vanalswaya, this submitted his original LSC to the Assistant Director of Survey as ordered. An order was issued on 14th August 2008, your Lordship has already seen that page number 12, to measure out the land of Mr. F. Vanalswaya's number so-and-so, located at Zonwam, and Mr. Lalbia Kluang Aparte, surveyor, was appointed to demarcate the land of Mr. T. Vanalswata in the process. As instructed, I was asked to purchase 4 angle iron, and on 26/8/2008, the land was demarcated in the presence of Zonwam VC members and YMA leaders. Angle rods were thus erected on all the 4 sites. While I was living contentedly, Mr. F. Vanalswaya approached the district court on 2 occasions to evict me from my own land. I am not in a position to vacate my own home and my land where I have settled for more than 10 years, to wander again without a home. I therefore request you to uphold and preserve my rights by directing Revenue Department to issue an LSC in the home that I live in my own name instead. Now this was accepted as written statement, my lord, and after that, no objection was raised to the written statement, and issues were framed, my lord, and the issues framed, my lord, are reflected in the judgment and order, impugned judgment and order, which is at page 66. Page 66, my lord, has got it?
Yes.
It's in bold, my lord. My lord, 6 issues were framed. The first one, whether the plaintiff is the legal and rightful owner of LSC number 10 so-and-so of 2006. B, whether the defendant number 1 was allotted a plot of land by Zone 1 Village Council in the year 1994 along with the plaintiff. If so, whether the defendant number 1 has any right to occupy the said plot of land. Whether there is any question of evicting a person from a plot of land if ownership of the same is under dispute. D, whether the defendant has willfully and under dispute, the reason they are saying is, my lord, because it's disputed in the revenue department. Whether the defendant had willfully and illegally built an Assam type house inside the plaintiff landed property. Whether the plaintiff is entitled to receive rents from the defendant for wrongfully occupying plaintiff's land. Whether the plaintiff is entitled to the relief claim, if so, to what extent. Now, these were the issues framed by the lower court, my lord, by the trial court. And evidences, my lord, were produced by both sides.
Now, let us go to the evidence. Where is it? Page.
My evidence, my lord?
Your evidence as well as the plaintiff's evidence?
Yes, my lord. I will start from the examiner. My lord, that document, my lord, that he had mentioned is at page 31. The lordship will turn to page 31. The document he had mentioned regarding the map, my lord. This is exhibit D3, my lord. Your lordship will see there is on the top, there is written Z3. Your lordship has seen Z3?
Z3, yes, Z3.
Z3F Vanal Ruata is written, my lord.
Yes, that's the defendant.
The appellant.
Oh, Vanal Ruata is the
sorry,
appellant.
sorry, my lord. That's the defendant.
That's the defendant. Yes.
And Z1C, my lord, below is, your lordship has seen it. F Vanal Ruai, something like that. Lal Ruaya. Z1C. Just below Z3, my lord. Z1C.
Z1C, yes, yes.
That is the appellant. Now, this map also was produced to us through RTI by the Revenue Department, my lord. I will show it to your lordship later. So it was not as if the Village Council had done this independently. It was under the instruction of the Land Revenue Department. Now, coming to the evidence, my lord, the plaintiff's evidence, which starts from page number 34.
Yes.
This is the PW number 1 plaintiff. I have, my lord, I have been residing in my land bearing LSC number so-and-so located at Luang Mual Veng Har Aizol, which is now called Zone 1, since November 1999 till date, and I have never encountered any problem. I have also paid taxes for my land regularly. In the year 2003, the defendant, without any pass, LSC, and without obtaining any permission from me, my lord, the question of obtaining permission from him does not arise in 2003. From me started constructing an Assam type house at the top of my land adjacent to the Jeep Road. I submitted a complaint to Revenue and Settlement Department in this regard, and the department appointed Mr. Lalko Bikal, surveyor, on 18/5/2008, via order dated 10/6/2008. These two people did not turn up on the said date, and my issue was thereafter not resolved. With this being the situation, I submitted another complaint to Revenue Department to ascertain my land boundaries and in the process evict the defendant from my land. Following up on the complaint, Revenue Department on 14/8/2008 issued another order directing Mr. Lalbiak Luang Aparte to perform demarcation spot verification on 26/8/2008. The surveyor came on the spot on the said day and demarcated my land. Since Revenue Department failed to issue any order even after this, I am left with no choice but to file this instant case before your honorable court. With this being the actual situation, I beg the honorable court to quickly evict the defendant from my land and upheld my rights in the process. And then the cross-examination, my lord, is at page number 36. So he had executed P1 as his plain signature, P2, the LSC, P3 and P4 your lordship had read at that time. And his cross-examination begins at page number 37.
Yes.
I personally know the defendant T. Vanal Ruata of this case. We are neighbors at Zone 1 locality at present. In this case, T. Vanal Ruata is the sole defendant, and I have not included the state of Mizoram as a defendant. During the year, they are pro forma defendant, madam. During the year 1994-95, the Village Council of Zone 1 allocated house site to residents of Zone 1 at Berampu Mual area, thus giving land to those who do not own a land. I was allocated my house site during this time, my lord. He is blowing hot and cold when he's saying that it is illegal. And this case arises out of this very land allocated to me. During this time, the defendant T. Vanalruata was also allocated a plot of land. My lord, he has admitted. When the village councils allocated us our respective land, we were instructed to build our own houses in it. If we failed to construct our house, the allotted plot was to be cancelled as informed to us by the village council. During the year 1999 and in the month of June, Zone 1 YMA constructed a house for me on the land allocated to me by the village council, and we started living here. So all the facts are correct, my lord, what we had stated in our written statement. After my house was constructed, I believe the defendant too constructed a house in May 2003. In the year 2006, Revenue Department demarcated my land and my LSC was issued. The land dispute between the defendant and me started after the LSC was issued to me. In the year 2008, I submitted a complaint to Revenue Department to resolve my issue with the defendant with regards to my disputed land. The Revenue Department has not taken any decision to resolve this issue till date, and my land dispute with the defendant has not been resolved. Exhibit P2 is the LSC issued to me by the Revenue Department in so and so. So my lord, my humble submission is this, that he has himself admitted that he was allotted the same plot of land and that the defendant also was allotted the plot of land. This is his cross-examination, my lord. Now, PW number 2, my lord, is at page number 39. Yes.
Who is this PW2?
Now, PW2, my lord, is supposed to be the local council, the present,
chairman.
the present at that time, not when the land was being demarcated and all. I am the present local council vice chairman of Zone 1. I was also the member of Zone 1 Village Council from 1999 till 2006. Okay, so he was then, my lord. Mr. F. Vanalruaya is the rightful owner of his land with witnesses like the Village Council, YMA and the government. He also possesses an original and duplicate LSC and he pays taxes every year. Revenue surveyors demarcated his land, and since I was the Village Council president during that time, I signed my name on the no objection paper as well. The land occupied by Mr. T. Vanalruaya was a vacant land even when Revenue Department prepared a house site plan in the year 2003. So my lord, this is also wrong. The land occupied by Mr. T. Vanalruaya and Mr. F. Vanalruaya adjacent to the main road was allocated as house pass to Mr. Vanalruaya by the Land Revenue and Settlement Department. And then, my lord, his cross-examination at page number 41. I am a witness to the fact that during the year 1994 to 95, even before I became member of Village Council, I knew that Zone 1 VC allotted a plot of land from Berampumwal area to those that reside inside our VC area but do not own a land. The defendant was one amongst those that received a plot of land during that time. My lord, the defendant, that's our client. The land allotted to him is the disputed land between him and the plaintiff. I know for a fact that the defendant too constructed a house on the land allotted to him by the village councils. However, I do not know the year of his house construction. They have been living in this house till today. Regarding the no objection mentioned by me in para 2 of my examination in chief, I do not know if the defendant signed his name too on that sheet. I believe he has not signed it. My lord, neighboring lands have to sign the no objection certificate. They did not produce it in court. As far as I know, the sued land between the plaintiff and the defendant is an ongoing dispute without any proper settlement. I know that the plaintiff constructed his house under the witness of the government as his house was constructed under a IAY scheme. I, however, do not know if the government performs spot verification or issues specific permission. I would like to further add that the plaintiff did not have any pass while constructing a house on his sued land. Regarding para 3 of my examination in chief, where I stated that the Revenue Department prepared a house site plan in my name of Mr. F. Vanalruaya, this was not prepared with the consent of Zone 1 Village Council. I have not deposed falsely before the court today. Now, re-examination, my lord. By saying that the defendant was given a land, it was merely a notice to construct a house. They do not have any papers to prove ownership. The defendant constructed his house only after the plaintiff owned a pass for his land. I believe the defendant was not called to sign on the no objection certificate sheet as he does not have any document to prove his ownership. By saying that the sued land is an ongoing issue between the plaintiff and the defendant, I meant to say that the case has not been disposed of yet. I know for a fact that the Revenue Department has already issued an LSC to the plaintiff for this sued land. I do not know when exactly Revenue Department issued an LSC to the plaintiff during the year 2006. I, however, signed my name when it was to be converted to LSC. During this time, no objection was not obtained from the defendant as far as I know. Now the next one is, my lord, the defendant number 1. This is the respondent number 1. Page number 43. I am the defendant number 1 in this case, and I am well versed with the facts of the case. It is not a fact that the land claimed as his by the plaintiff F. Van Roy bearing so and so located at Zone 1 locality as all belongs to him entirely. So we are not saying that, my lord, all of the LSCs are not his. The actual truth goes like this. After we vacated Remnerun in the year 1986, I resided at Zone 1 Aizawl. I even had a wife and children in Zone 1 area, and I still reside here till today. During the year 1994, the village council of Zone 1 decided to allot a plot of land from Berampumwal to poor residents who do not own a home in our locality. They have a certain various plots, and I was allotted plot number Z3 during this time. After the village councils allotted us our respective land, those that were able to construct a house started construction work immediately to facilitate quick pass issuance from the Revenue Department. As for me, I could not start my construction work due to financial constraints. After procuring LIC loan in the year 2002, I was able to construct a house on my plot of land. After we completed the house construction, my family moved in immediately, and we have been staying here till today. All this time, there never was any land issue between us and our neighbors. Mr. F. Van Roy too never had a problem with us during these days. While we were peacefully settled in this area, our land was demarcated in the year 2003 for issuing house pass. On this day, I was not present as I was not informed. The pass of this land demarcated in 2003 was only issued in the year 2006. When the pass was issued in 2006, I came to learn that my house area was included inside the LSC of Mr. F. Van Roy. On realizing the situation, I approached the government officials as I had nowhere to turn to. On 18/7/2008, the authorities of Revenue Department office called me and my land issue was discussed. Mr. Lal Mehta, who was the VC of Zone 1 during 1994, when the land was allotted, was also present on this day. Post this, the Revenue Department appointed surveyor Lal Biakluang Aparte to demarcate our land on 26/8/2008. My land boundary was thus measured, and Mr. Van Roy was also present on that day. On this day, the actual boundary was identified, and the boundary pillars were to be erected as per our consensus. I have also erected boundary pillars as decided on that day. Mr. Van Roy did not show any objection that day. However, he did not erect any boundary pillars of his land. While we waited for the result of our land demarcation, along with a detailed description of our respective land boundaries, Mr. F. Van Roy instead approached the court and filed this instant case. As I am the type of person who does not want to have any issues with neighboring landowners, I do not feel at ease with this issue. I, however, cannot accept my land being a part of Mr. F. Van Roy's LSC without my knowledge and consent. My contention is for the court to resolve this issue and ascertain the exact area of Mr. F. Van Roy's LSC along with the exact area of my land area. Now, cross-examination, my lord, at page number 46. So he had exhibited certain documents, my lord. First is the copy of the order dated 14/8/2008. Then exhibit D2 is 15/7/2008. Exhibit D3 is that map which I had already shown your lordship. All the documents, it says like this, my lord, they have made an objection. All the documents exhibited are objected to by the plaintiff for absence of original proof. Original proof were only supplied, my lord, through that additional document. Now, cross-examination by DL. It is a fact that I do not bring the original documents of Exhibit D1 and D2 before the court today. It is also a fact that Exhibit D3 was not issued by the Revenue Department or the state government. Now, my lord, he has got this wrong because it was the Revenue Department. I will show your lordship. 3. It is also a fact that Exhibit D3 does not bear the seal of any authority, including the Village Council of Zone 1 Veng Aizawl. It is also a fact that I do not have any documents issued by competent authority to show that I have title or ownership for possessing the suit land. It is also a fact that I have not filed any suit either against the plaintiff or the state government challenging the issuance of LSC in favor of the plaintiff, which is now covering the suit land, including the site where I built my house. It is also a fact that I have no document today to show that the Village Council Authority of Zone 1 Veng Aizawl had allotted me the suit land in 1994. I have no document. My lord, all the questions asked were about documents. I have no document today to show that the plaintiff's LSC number so and so was to be partitioned into two by giving me a portion after site survey conducted by Pulalbia Kluanga Parte and subsequently discussion held at Revenue Office. It is not a fact that the Village Council Authority of Zone 1 has no authority to allot house sites within Aizawl City. It is not a fact that Exhibit D1, D2 and D3 are false and fabricated by me so as to wrongly show my title to the sued land. It is not a fact that I am deposing falsely before the court today. Re-examination. By saying para 7 of my cross-examination that I want to mention is that though I have no document to show that the plaintiff's LSC has to be partitioned into two, at present, however, I have applied for the said document by filing an application by way of RTI to the concerned authority, and the said application is still pending till today. Now, my lord will see the RONAC. The date of signature, my lord, is 9/6/2006. Now, the documents which I have submitted, which we had submitted, my lord, before this court, if your lordship will see, the date of issuance of this RTI application reply, my lord, was 17 June 2016. So, my lord, it was issued around 10 days after that cross-examination. So, on that day, my lord, he was rightfully saying that he did not have those documents.
RTI replies obtained on?
Obtained on, my lord, if your lordship, was obtained on 17/6/2016.
17/6/2016.
We received the reply on 17/6/2016. It's reflected at page number 10A, my lord, of that IA. Page number 10A, madam.
Okay, 17/6/2016. Yes.
I'll take your lordship to the application later, my lord.
But on 17/6/2016, the suit was not yet decreed, isn't it?
Not yet decreed. My
Then
lord,
you could
he had also done one thing, my lord. I am going to be very honest, my lord. He should have, I mean, in the application we had mentioned, my lord, that he had supplied it to his advocates, but perhaps his advocates were confident, my lord, that he was going to win the case and therefore did not submit. But, my lord, what they should have done was they should have definitely taken steps to submit in court. I'm not going to deny this. I mean, they should have
That's
done it
right.
out of abundant caution.
Even
as well.
at that time, by way of additional documents, it could have been produced before
They
the trial court.
They should have. But, my lord, my submission is this. Be that as it may, they should have submitted. My lord, I have cited that Supreme Court judgment from yesterday. So the question is not whether they have the opportunity, but the question is whether this court, my lord, I'm not sure whether your lordship wants to see them, but the question is whether your lordship wants to see them. Anyway, my lord, I'll take your lordship to page
No,
number
that judgment says if it will help the court in coming to a right decision.
Correct. So if your lordship thinks it will help you, my lord, then only.
We'll see.
Yes. My lord, at page number 51. This is the PW number 2. Sorry, the DW number 2.
DW.
Yes. Lal Ropuya, my lord, age 59. Paragraph 1. I know both the plaintiff and the defendant of the instant case as they are my close neighbors. I know that in the year 1994, Zone 1 Village Council allotted many plots of land to the residents of Berampur Molveng. At that time, I was also allotted a plot of land by the said VC under plot number Y9. Now, my lord, this is something, I ask myself this question, my lord. I fail to understand, my lord, how they can say that this allotment is illegal, my lord. Because all of the residents in that area, they have been allotted plots of land. He has been allotted the same plot of land, my lord. I fail to understand. It's like shooting your own toe. My lord, there's...
That map which is there,
yes.
that is produced by?
My lord, in the RTI reply we received.
Oh, in the RTI reply.
Yes, we got it from the RTI reply as well. We got the same map from the RTI reply from the revenue, which means it was under the authority of the land revenue. Your lordship will see the same map in the IA. IA page number 21.
Whereas you had exhibited
Yes,
before
we had exhibited.
in the trial court.
In the trial court, my lord, we did not have the original. We got the Xerox and we had exhibited. Now the RTI reply also, my lord, we were supplied by that same document at page 22. Page 21. 22.
22.
Yes, same document, my lord. So to say that this was only prepared by the village council, my lord, is not correct. The seal, RTI seal also is there. I know that in the year 1994, Zone 1 Village Council allotted many plots of land to the residents of Berampur Mualveng. At that time, I was also allotted a plot of land by the said VC under plot number Y9. Thereafter, sometime in the year 1998, I built a house therein, and thereafter, I and my family began to live in the said house till date. Accordingly, I was issued an LSC by the competent authority in respect of the said plot of land. That I know that the defendant T. Vanal Ruata as well as the plaintiff F. Vanal Ruaya were also allotted plots of lands by the said village council in the year 1994. As far as I know, the defendant T. Vanal Ruata had built a residential house within the plot of land allotted to him sometime in the year 2002, and since then he and his family continued to live therein till date. At the same time, I also know that since the plaintiff F. Vanal Ruaya was not in a position to build a house due to financial reason, the YMA Zone 1 constructed a house for the plaintiff and his family, wherein the plaintiff and his family continued to live till date. That I also know that the plaintiff was issued LSC by the Revenue Authority by overlapping the plot of land belonging to the defendant. As soon as the defendant came to know of the said LSC, he made a complaint before the Revenue Department. The Revenue Department then sent a surveyor to conduct a spot verification. Accordingly, spot verification was conducted in the presence of VC and YMA. At that time, the land belonging to the plaintiff as well as the defendant were verified and boundary pillar were erected. At that time, it was found that the boundary of the LSC number so and so belonging to the plaintiff needs to be modified and corrected. Now, this is corroborated by the documents we will submit. In spite of this, the plaintiff still claimed ownership over the plot of land belonging to the defendant till date. That, in my opinion, the plaintiff has no right or title to claim for ownership over the plot of land which the village council Zone 1 had allotted to the defendant in the year 1994. Now, my lord, his cross-examination at page number 53. It is a fact that I stayed at Zone 1 area since 1994. It is a fact that I am a relative of the defendant T. Vanal Ruata, and as his wife is sister of my wife's father. It is a fact that there is no document in the court today to show that the defendant was allotted a plot of land at the suit land. I do not know whether the defendant possessed any pass or any documents issued by competent authority in his favor in respect of the suit land. I do not know exactly when the defendant built his house in the suit land. I do not have any document to show that the LSC of the plaintiff overlapped that of the defendant. It is a fact that the LSC number 103702 so and so was issued in favor of the plaintiff by the Revenue Department in respect of the whole suit land. I do not have any documents in the court today to show that the defendant made a complaint before Revenue Department regarding LSC of the plaintiff. I do not have any documents in the court today to show that spot verification was conducted and the LSC number was so and so was required to be modified and corrected. It is a fact that the plaintiff has right of title. It is not a fact that the plaintiff has right of title and ownership over the plot of land presently occupied by the defendant in the suit land. Now there are three more witnesses, my lord. The next is the DW number 3, my lord. I was the president of YMA Zone 1 branch for around 15 years, and as such, I know both the plaintiff and defendant of the instant case. I know that in the year 1994, Zone 1 Village Council allotted many plots of land to the residents of Berampur Mualveng. I know that the defendant T. Vanal Ruata as well as the plaintiff F. Vanal Ruaya were allotted plot of lands by the said village council in the year 1994. As far as I know, the defendant T. Vanal Ruata had built a residential house within the plot of land allotted to him sometime in the year 2002, and since then he and his family continued to live there until date. At the same time, I also know that since the plaintiff F. Vanal Ruaya was not in a position to build a house due to financial reasons, the YMA Zone 1 constructed a house for the plaintiff and his wife and his family, wherein the plaintiff and his family continued to live till date. In fact, I was the president YMA Zone 1 branch at the relevant time. I also know that the plaintiff was issued LSC by the revenue authorities by overlapping the plot of land belonging to the defendant. As soon as the defendant came to know of the said LSC, he made a complaint before the Revenue Department. The Revenue Department then sent a surveyor to conduct a spot verification. Accordingly, spot verification was conducted in the presence of the landowners, VC and YMA, and being the president of the YMA concerned, I was also present at the spot at the time of the spot verification. At that time, the land belonging to the plaintiff as well as the defendant were verified and boundary pillars were erected. At that time, it was found that the boundary of the LSC number so-and-so belonging to the plaintiff needs to be modified and corrected, and as a result, it was agreed at that time that necessary passes be issued in favor of both the plaintiff and the defendant by modifying the LSC which was issued in the name of the plaintiff. After arriving the said agreement, the revenue authorities were expected to take necessary steps for the same. In spite of the above mentioned agreement arrived at by the parties at the time of spot verification, and while the revenue authorities were supposed to issue fresh land passes in favor of both, now my lord, the reason why they have not issued also will become clear with the documents we submitted. In suit against the defendant claiming ownership over the whole plot of land, that in my opinion, the plaintiff has no right or title to claim for ownership over the plot of land which the Village Council Zone 1 had allotted to the defendant in the year 1994 due to the facts and circumstances stated above. In fact, the plaintiff is bound to abide by the agreement arrived at during the time of the spot verification, my lord. This agreement also, my lord, I will show you later. Now, page number 56 is the cross-examination. It is a fact that the defendant T. Vanal Ruata do not have any land passes, including LSC, periodic pata, and VC pass in respect of the suit land till date. It is a fact that I did not see any document of land allotment issued by competent authority in respect of the suit land till date. It is not a fact that Luang Molveng, third branch of YMA, did not build the house for the defendant at the suit land as he was allotted any plot in his favor. It is a fact that I do not have any document to show that the land of the plaintiff is overlapping that of the defendant. It is not a fact, because this is an oral evidence, my lord. It's not for him to produce the document. It is not a fact that the plaintiff did not give his consent for slicing out land for the defendant number 1. It is a fact that I do not have document to show that spot verification was conducted in my presence and amicable settlement was made for splitting the land of the plaintiff. Since the plaintiff is now possessing LSC in his favor in respect of the suit land, I cannot say whether the plaintiff is the legal owner of the suit land. It is not a fact that I am deposing falsely before the court. Re-examination. Though I have stated under para number 6 of my cross-examination that I have no document to show that the spot verification was conducted, what I want to say in this regard is that a written record was made in this respect, but I do not bring the same, and as such I cannot produce before the court today. Now these written records are all there. Page number 57, my lord. This is the second last witness. I was a member of Village Council President, Zone 1 branch, Village Council Zone 1 branch for around 12 years. And as such, I know both the plaintiff and defendant of the instant case. I know that in the year 1994, Zone 1 Village Council allotted many plots of land to the residents of Berampu, Molveng. That I know that the defendant T. Vanal Ruata as well as the plaintiff Vanal Shuaya were allotted plots of lands by the said Village Council in the year 1994. As far as I know, the defendant T. Vanal Ruata had built a residential house within the plot of land allotted to him sometime in the year 2002, and since then he and his family continued to live therein till date. At the same time, I also know that since the plaintiff F. Vanal Shuaya was not in a position to build a house due to financial reasons, the YMA Zone 1 constructed a house for the plaintiff and his family, wherein the plaintiff and his family continued to live till date. In fact, I was a member of the Village Council Zone 1 branch at that time. That in my opinion, the plaintiff has no right or title to claim for ownership over the plot of land which the Village Council Zone 1 had allotted to the defendant in the year 1994, and that both the plaintiff and the defendant are to be given title ownership of land based on a plot of land previously allotted to them by the Village Council Zone 1 at the relevant time. That the statements made by me in this para and so. I got cross-examination at page 59. I began to live at Zone 1 area since 1995. I also used to have my own residence. It is a fact that I could not state the exact year when I was member of Zone 1 Village Council, but I know that it was for 5 terms consecutively. It is a fact that I do not have any document today to show that defendant number 1 was allotted a house site plot by the Zone 1 Village Council in 1994. It is also a fact that I do not know exactly when the defendant number 1 built his house inside the disputed land. It is also a fact that I do not know the exact time when the defendant number 1 began to live in his present house. I also do not know the year when the residence of the plaintiff was built. It is not a fact that I was present when the house of the plaintiff was built. It is a fact that I do not know that the plaintiff is having an LS in respect of the suit land. It is also a fact that defendant number 1 is not having any pass in respect of the suit land. I do not admit that the holder of LSC is not owner of the land in as much as the defendant number 1 was also allotted plots by the Zone 1 Village Council. It is the fact that the Zone 1 Village Council was not competent to issue any pass for the house site at the suit land at the relevant time. My lord, this my lord, will have to be re-examined based on the record, my lord. 12. It is not a fact that I appear before the court today on behalf of the defendant number 1 on payment of benefit and pecuniary gains. It is a fact that I appear before the court today on the request of the defendant number 1. Re-examination. Though I have stated at paragraph number 11 of my cross-examination that the Zone 1 Village Council was not competent to issue any pass for house site at the suit land at the relevant time. However, the Revenue Authority issued land passes on the basis of recommendation issued by the Zone 1 Village Council. The land pass issued to the plaintiff was beyond the recommendation made by the Zone 1 Village Council in favor of the plaintiff. Further cross-examination by the plaintiff counsel. It is a fact that I do not know at present the area of land allotted to the plaintiff and the defendant number 1 at the suit land. It is also a fact that I do not have any document to show that any land plot was allotted to the defendant number 1 at the suit land. I do not know on the basis of what provision of law the recommendation made by the village council is required for issuance of LSC by the revenue authorities. Re-examination by the defendant counsel. Even though I cannot say the exact area of the land allotted to the plaintiff at the present, however, I clearly know the boundary of the land plot allotted to the plaintiff at the suit land. Now, my lord, the last witness. Page number 60, my lord. I had been a member of Zone 1 Village Council for a period of 4 terms, during which I was elected as the president for a term and a half. And as such, I know both the plaintiff and defendant of the instant case. That I know that prior to my tenure in VC Zone 1, the defendant T. Vanalruata as well as the plaintiff F. Vanal Shwaya were allotted plots of lands by the state village council. As far as I know, the defendant T. Vanalruata had built a residential house within the plot of land allotted to him sometime in the year 2002, and since then he and his family continued to live there until date. At the same time, I also know that since the plaintiff F. Vanal Shwaya was not in a position to build a house due to financial reasons, the YMA Zone 1 constructed a house for the plaintiff and his family, wherein the plaintiff and his family continued to live till date. That when a spot verification was conducted by the Revenue Department in the presence of the land owners, VC and YMA, I was also present. At that time, the land belonging to the plaintiff as well as the defendant were verified and boundary pillar were erected. At that time, it was found that the boundary of the LSC number so and so belonging to the plaintiff needs to be modified and corrected. And as a result, it was agreed at that time that necessary passes be issued in favor of both the plaintiff and the defendant by modifying the LSC which was issued in the name of the plaintiff. After arriving the said agreement, the revenue authorities were expected to take necessary steps for the same. In spite of the above mentioned agreement arrived at by the parties at the time of spot verification, while the revenue authorities were supposed to issue fresh land passes in favor of both the plaintiff and the defendant, the plaintiff instituted the instant eviction suit against the defendant, claiming ownership over the whole plot of land. Now, my lord, this next page, this cross-examination, my lord, I'm not sure if this is valid because this is unsigned, my lord, and I think it was subsequently submitted. I think something's wrong with that one, my lord. But anyway, my lord, I will read it.
Yes.
It is a fact that I have been living in Zone 1 since June 1998. This is unsigned, my lord. It is a fact that I know the plaintiff and the defendant number 1 personally. It is a fact that I do not have any documents to show that the defendant number 1 was allotted house site by the Zone 1 Village Council in 1994. It is the fact that I do not know when the defendant number 1 built his house at Zone 1. It is a fact that defendant number 1 was living at Zone 1 before we came to live at Zone 1. It is a fact that disputed land bearing so and so belongs to the plaintiff. It is a fact that I do not know whether the defendant number 1 have any pass in respect of the suit land. It is a fact that I do not know whether the house of the defendant number 1 is inside LSC of the plaintiff, as I have not seen the LSC personally. It is a fact that Zone 1 Village Council was not competent to issue any pass for house site at the suit land at the relevant time. It is a fact that I do not know whether the plaintiff and the defendant number 1 came to agreement in respect of the suit land. I do not know whether the defendant number 1 made any complaint in respect of the suit land. It is not a fact that I am deposing falsely before this court today. re-examination. In spite of what I had stated at paragraph number 10 of my cross-examination, I would like to state that an agreement in respect of the suit land was executed by the plaintiff and the defendant number 1 under the guidance of the revenue authorities therein, wherein I was requested to stood as one of the witnesses. Accordingly, I put my signature in the said agreement. Cross-examination. It is a fact that I do not have any document to show the alleged agreement was actually executed, nor do I know whether the plaintiff and the defendant number 1 signed the agreement. Now, these next 2 pages, my lord, seems to be completely different. They are not from this present case, my lord, because they talk of money and all. Now, my lord,
Yes, this 20,000, 30,000 and all, what is this?
my lord, I think this is from a different case. By mistake, it must have come in this case, my lord.
Oh, could be.
Now, I'll quickly take your lordship to the additional documents we had submitted, my lord.
1 minute, okay.
The first document we had submitted along with the RTI. So this entire thing came with the RTI, my lord. Reply dated 17/3/2016. Now page number 11, my lord. This is the Mizo translation, the Mizo version. This was the same document, my lord, I had already read that time before, which was already exhibited by the parties. This was the order dated 14 August 2008. Now, my lord, this next document, my lord, at page
14th August 2000. Oh, this is that for the demarcation.
Demarcation. Now, the next page after that demarcation, my lord, if your lordship will turn to the next page, the internal page number 3, my lord.
Yes.
This was of 12 January 2010. Now, my lord, it says like this: to the Settlement Officer 1, Land Revenue and Settlement Department, partition of LSC number 1006 of 2006. With reference to the subject cited above, I have the honor to convey herewith approval of the Director, Land Revenue and Settlement for partition of LSC in respect of Q.F. Vanar Shuaya on payment of the required demarcation and mutation fee as fixed by the government. Now, this fee, my lord, has not been paid by the appellant till today. And this is the reason why it has not yet been issued, my lord, the new fresh ones. Now, my lord, they have enclosed all the connected documents. If your lordship will see block 1 and block 2, the names are already given, my lord, at page in this. Block 1 says T. Vanal Ruata. The same page, my lord.
Same page.
The same page.
Oh, chum. Block 1.
Block 1, T. Vanal Ruata, 132.43
square meter.
Yes. And F. Vanal Shuaya, 206.
206.35.
Yes. So I am still getting a smaller land, my lord. Now, next page, my lord, is the document that came along with this document, the connected documents, my lord. And if your lordship will see, I'll read the technical observation. This was before the approval. Now, the first page was the approval letter. Technical observation. F. Vanar Shuaya had give some portion of his LSC area to T. Vanar Ruata and he applied for bifurcation. Demarcation had done by SR and reported there's no encumbrance. Demarcation had been done with the presence of VCP YMA only for pillar of AI has fixed in addition to remaining fixed pillars. So, my lord, this is all in line with the examination in chief. Report checked, technical found correct, excess area 6.42 meters arises. Text not cleared. Let them clear text before further processing. And then it goes on, my lord. Next is it continues, it says tax payee certificate enclosed. So, my lord, they cooperated with this also, both the parties. Tax payee certificate enclosed, block 1 and 2, holder already mentioned, no technical error found, may be found so and so. Then it says, my lord, approval number so and so, 12/1/2010. So, approval 12/1/2010, Q.F. Vanar Shuaya, LSC, bifurcation, report, so-and-so report, bifurcation, my lord, this part I cannot read, I'm sorry, my lord.
Bifurcation official report
Official report was
was
enclosed.
checked.
Yes, so this was the approval letter, it was enclosed. Now, the next page, my lord, is, it has the heading is like this, report form B for house side LSC alteration, extension, correction, my lord, on top it's written. And the next page is the English translation, my lord. Since the English translation is not, I'm not sure if this is completely accurate, my lord. This is subject to correction from the registry. Below, my lord, comments and remarks. At the time of measuring the land, owners of both neighboring lands were present. VCP and YMA president are also present. It was partitioned without any issues. Pillars are also planted. My lord, there it says, they are made to buy only four pillars as all pillars are used. They said original pass has already been submitted in the office. My lord, he has surrendered the original pass in the office. It has not been enclosed. And then next, my lord, is the boundary descriptions. The next page, your lordship will see. These are all very sophisticatedly written, my lord. So the translation is completely not accurate. But the fact remains, my lord, this is the boundary description.
There was a boundary description.
And then, yes, my lord, it goes on. And finally, my lord, at page number 17, my lord, I will read, my lord. Page number 17A, my lord. This is the English translation.
Yes.
My lord, towards the bottom, the last paragraph, it says like this. Therefore, the entire area is 206.35 square meters is equal to so and so. The yearly land tax has been calculated by taking into consideration the area of so and so. This LSC number has been demarcated in favor of T. Vanal Ruata. This person will continue to hold the original LSC number so and so. Since it is larger than the original LSC by 6.42 m, he will pay it should be redemarcation fee. So the redemarcation fee has to be paid by the appellant. Now till today he has not paid. And next page, my lord, is the new map of his land. This is the new map of the LSC of F. Vanal Fuaya.
This person will continue to hold the original LSC.
Next page, my lord.
Yes.
This is a new map, and your lordship will see date of survey
Page 18.
is 26/8/2008. Date of survey is also 26/8/2008. And then,
But in that village map, in between your lands, there was a road. But here again, it is coming out different.
no, it's not a road, my lord. Your lordship will see, my lord, come to the same one, the same document at page 22. Page 22. This is from the revenue department, my lord.
Oh, yes. The road is on top.
On top. So there's no road.
Okay, let's continue at 2.
Certainly, my lord.
My lords,
Yes.
I know this is not the right time to make a mention, my lords, but we are waiting for item 3, part 2, my lord.
Okay.
It's fixed for today, my lord.
Yes, I think we may not be able to.
Yes,
take
exactly,
it up.
that's why.
Yes, item 3.
Yes, of part 2.
When do you want?
If in the week commencing from 10th November, my lord.
Okay, just write it down, Court Master. Yeah. On the mention of the Permanent Councils for the parties, list the matter.
Week commencing from
The
10th.
week commencing from 10th November. Okay.
I'm deeply obliged, my lord.
Lord, I think I had just shown your Lordship the map.
That map, yes.
Yes. So that map which we had submitted is also in line with the same map which was sent, which was provided to us by the Land Revenue Settlement Department. Now, my Lord, finally, my Lord, if your Lordship will turn to page number 23, Lordship. The appellant. This is a Mizo translation. This is a Mizo version, my Lord. The English translation is in the next page. This is the title of the letter is not given in the English translation. Sorry, in the Mizo translation, my Lord. But it says like this: Mun in pek na lekha means a document for gifting of land.
Page 23.
Page 23.
Oh, page 23. Okay.
Mun in pek na lekha means, my Lord, document for gifting of land.
Gifting of land.
Because during those days, my Lord, the Registration Act was not applicable in Mizoram. So in addition to all of the things that I had already mentioned, my Lord, he had also submitted this document. And the English translation says like this, my Lord. Today, dated 26/8/2008, this was soon after that demarcation was made. I have allotted my land, garden, WRC shop, stall, LSC number so-and-so, area 332.41 square meter wide to the following person. The reason for my allotment, in Mizo it says das ka sathak. Here, my Lord, it should have been ka sathak means I have sliced out. It is sliced out. Sliced out from his land. And it goes on, my Lord, like this. He says, I promise that after the mutation of the land by the government, it cannot be taken back. I will not interfere. And then he had signed in this document, my Lord. And my Lord, he had also submitted another additional document which is at page number 24.
Yes.
This is document called Application for Partition, Alteration / Extension of LSC. And there also, my Lord, he has signed the document. Signature is there. Serial number 8, my Lord. LSC 1022 say Bolania means, my Lord, I think we had not translated that one properly. It says the LSC which is supposed to be demarcated, is it used? Or say ball means, my Lord, is it being what do you call it, my Lord?
Let's see. This part is not translated.
This is not translated.
Say
Say ball would be what? Would be not decorated also, my Lord. Whether it has been developed, I think that would be the right word, my Lord. The LSC which is supposed to be, which is to be demarcated, which is supposed to be sliced out, is it developed? And it says yes. Nie means yes, my Lord. And then on top it says 7. Engvanga LSC to 10 dunge ini. Why do you want to demarcate, slice the LSC? It says because I gave some plot of land. So the Revenue Department has also demarcated. He has also submitted these documents, my Lord. These were all in 2008. And then this is not the end, my Lord. If your Lordship will come to page number, no objection.
Acha, this para 10B, that is not filled up.
Which one, my Lord? Para
This
10.
in that same document, after para 10, there is a B, serial number B, where some questions have been asked. Why do you want to mutate? Why do you want to widen? How much
Yes.
do you want to- This is left
No,
blank.
no, that is not filled up. And then, my Lord, serial number 10, it says, who is going to be the owner? Aneitu Turming T. Vanal Shuaya. So that is the defendant, sorry, the respondent. And then page number, my Lord, 20. Page number 26, my Lord. is the no objection certificate. This is the Mizo translation. The English translation is the next page, my lord. 26A.
25A.
26A.
26A.
I'm sorry, my lord, these translations were not done very well, my lord. I'm sorry. Says no objection certificate. I was present on date 26/8/2008 when Mr. T. Vanlal Ruala land was measured. When it's supposed to be T. Vanlal Ruata's land. T. Vanlal Ruata's land was measured, and I accept the way the surveyor had measured it. I also have no objection, it should be. I also have no objection with respect to the issuance of LSE. So this, he had signed in this. He is the first person to sign this document. And then, Lordship will see page number 27 is this is the new map which has also been drawn, in addition to the one I had already showed your Lordship. It's quite sophisticated, my Lord, so it's quite very difficult to explain, but I think this is how it has been measured. And then your Lordship will see the iron rods, my Lord. 29, my Lord, page number 29.
Page 29. But this is the cash memo.
Cash memo, Lordship, it was mentioned in the in chief and oral evidence that they had bought those iron rods and all that.
Angle post.
Angle post. So this is from the revenue department, my Lord. And the next one is the Shiatpuina, this is the acknowledgement.
This for assistance, which is
from the village president. And the next one is from the president of the YMA.
And what is this, page 32?
Page 30. This was also supplied to us by the revenue department. This was the submitted LSC.
It is the LSC of the appellant.
Appellant, submitted to the land revenue department. He had already submitted, my lord. It was also approved. Everything was done, my lord. The only thing that needed to be done was payment of the redemarcation fee. And then the new LSC was going to be supplied to us. Now, instead of doing all of that, my lord, he had come to this court. After all of what he had done, my lord, he is stopped. My lord, this is my humble submission, my lord, that firstly, my lord, the appellant has kept quiet about this. He was hiding these facts, my lord. And these facts are pertinent to the case in hand, my lord. He has not come to court with clean hands. And on top of that, my lord, he is blowing hot and cold. Firstly, he signs the no objection certificate. He submits those documents I had just shown your lordship. And then after all of that, my lord, without bringing any of those things on record, without challenging it, my lord, the approval of the Land Revenue and Settlement Department needs to be challenged. Without challenging any of those things, my lord, he is claiming that his LSC was how it was in 2006, even though his LSC has already been altered by the Land Revenue and Settlement Department. The maps have already been redrawn. My lord, we have two stories. We read the story of the appellant in his plaint. My lord, we know that his stories have hidden a lot of facts, and then it's not in sequential order also, my lord. And we have our story which is corroborated by all the documents we have submitted, my lord. So we have these two stories, and considering the stories that we have submitted, I mean these two narratives, my lord, it is very, very clear that this LSC has already been redemarcated, and that the defendant, the appellant has no right over the area covered by the that the defendant is occupying presently, my lord. And if your lordship will come to the impugned order, my lord, I'll quickly take your lordship to the impugned order. Now at page number 46, paper book. In the paper book, it starts from page number 76, the relevant portions. Now, my lord, these are the findings of the court, my lord. I'll read from paragraph number 24. The first issue, whether the plaintiff is the legal and rightful owner of LSC number 1037021/so-and-so. A, in my opinion, the plaintiff is not the legal and rightful owner of LSC number so-and-so. From the materials on record, it appears to me that the pro forma defendants has committed a grave mistake by issuing the LSC in the name of the plaintiff, which included the whole area occupied by both the plaintiff and the defendant. Therefore, the plaintiff cannot be declared legal and rightful owner of LSC number so-and-so. Now 25. Whether the defendant number 1 was allotted a plot of land by Zone 1 Village Council in the year 1994 along with the plaintiff, if so, whether the defendant number 1 has any right to occupy the said plot of land. Since both plaintiff and defendant and all their witnesses had deposed that the Village Council of Zone 1 had allotted many plots of land to residents of their locality in the year 1994, therefore, it is declared that the defendant was allotted a plot of land by the Village Council of Zone 1 in the year 1994, and he has the rights to occupy the plot of land allotted to him. 26. Whether there is any question of evicting a person from a plot of land if ownership of the same is under dispute. Now, the court had ruled like this, my lord. This issue is question of law, and I strike out this issue as provided by Order 14, Rule 5, as I am of opinion that it had been wrongly framed. Now, 27. Whether the defendant had willfully and illegally built an assum-type house inside the plaintiff landed property. Since it is declared that the defendant was allotted a plot of land by the Village Council of Zone 1 in the year 1994, and he has the rights to occupy the plot of land allotted to him. Therefore, it follows that he has built an assum-type house on the plot of land as allotted to him, and not inside the landed property of the plaintiff. As such, this issue is decided in favor of the defendant by declaring that he had legally built an assum-type house on the plot of land allotted to him. Now 28. Whether the plaintiff is entitled to receive rents from the defendant for wrongfully occupying plaintiff's land. Since it has been declared that the defendant had legally built an assum-type house on the plot of land allotted to him, the plaintiff is not entitled to receive rents from the defendant. As such, this issue is decided in favor of the defendant by declaring that the plaintiff is not entitled to receive rents from the defendant. 29. Whether the plaintiff is entitled to the relief claims, if so, to what extent. Since the issue B, D, and E has been decided in favor of the defendant, I hereby declare that the plaintiff is not entitled to none of the reliefs claimed by him. In order to determine the dispute between the parties and to put an end to this litigation, I am of the opinion to frame additional issue as provided by Order 14 Rule 5. Therefore, an additional issue is framed as follows. Whether both the plaintiff and the defendant entitled to absolute ownership of the land allotted to them, Zone 1 Village Council, in the year 1994 and occupied by them till today. Both the plaintiff and the defendant had been allotted a plot of land by the Zone 1 Village Council in the year 1994. They had occupied the land separately without any encumbrance until the year 2006. When dispute arose in the year, it was because of the action of the pro forma defendants. The pro forma defendants has committed a grave mistake by issuing the LSC number so-and-so in the name of the plaintiff, which included the whole area occupied by both the plaintiff and the defendant. Therefore, the pro forma defendants are directed to issue separate LSC to both the plaintiff and the defendant without unnecessary delay in respect of land occupied by them at Berampum Wolveng, Zonuam Aizol. The boundary pillars erected by the defendant, which is still standing today, shall be considered as correct boundary between the plaintiffs and defendant's plot of land. Now, my lord, the court was not privy to the things we had submitted, my lord, to this court. The revenue department has, in fact, my lord, made all the demarcations already. 32. Regarding cause of the suit, since the plaintiff had unnecessarily dragged the defendant for frivolous litigation, I am of the opinion that he should pay exemplary cost. However, since the defendant had been assisted by legal aid, counsel provided by District Legal Services Authority as all, the sum of rupees 10,000 is sufficient to meet the ends of justice. Therefore, the plaintiff shall pay the sum of rupees 10,000 as cause of the suit. The pro forma defendants are further directed not to issue the LSC to the plaintiff until the cost is paid by the plaintiff. Payment of cost shall be intimated to the pro forma defendants by the court as soon as payment is received. So, my lord, my humble submission is that the lower court, I mean the trial court, had also made the correct decision, my lord, on these points.
Yes. Anything else?
Yes, my lord, I had already submitted that legal point, my lord. I think section 21 of the Mizoram Civil Courts Act, my lord, regarding that.
Regarding the written statement.
Written statement and spirit. Now, my lord, if I may also cite one more Supreme Court judgment on this point, my lord. This was a judgment of the Supreme Court reported in 2019-6 SEC 756. 2019-6 SEC 756. In addition to the spirit, my lord, this is my submission at page number 760.
760.
Yes. My lord, at paragraph number 11.
Yes.
Even though the court was discussing Order 22, Rule 3 CPC, my lord, but it says like this. Death of a party during the currency of a litigation indeed has given rise to vexed questions. Procedure, my lord. Procedure is the handmaiden of justice. The technicalities of law should not be allowed to prevail over the demands of justice, and obstacles in the path of the court, considering a case on merit, should not ordinarily become insuperable. On the other hand, if the so-called procedural requirement is drawn from a wholesome principle of substantive law, my lord, in our case, it's not drawn from a wholesome principle of substantive law, to advance the cause of justice, the same may not be overlooked. So in addition to spirit, my lord, my humble submission is that the written statement, of course, my lord, was not written how it would probably should have been written under CPC, my lord. But even in that case, my lord, my humble submission is that in light of this Supreme Court judgment, that procedural requirement should be overlooked. And my lord, there is another Supreme Court judgment I would like to cite. This is 2016, volume 12. My lord, and I would also like to point out one thing, my lord. When my learned friend had cited that law regarding WS in his submission, my lord, that law regarding WS he had cited was with respect to Article 226. That case he had cited was a writ petition, my lord. So it's not CPC or things like that, my lord.
Okay. That was 2011 3 SEC.
Correct, my lord, that regarding written statement. And this judgment I am producing, my lord, is reported in 2016, volume 12.
Volume 12.
Yes, 2016, volume 12, page number 129. The relevant portion, my lord, is at page number 129. paragraph number 7, the last sentence, my lord. It says like this, my lord. As was held by this court in Chitturi Subana versus Kudappa Subana, a pure question of law, which is not dependent on the determination of any question of fact, may be raised for the first time at the appellate or even the final stage, even though no reference to it had been made in the courts below. Now, my lord, the reason I'm citing this is my learned friend's pleading, if your lordship will remember, in the plaint has not mentioned anything, my lord, regarding regarding whether that area lands can be given by the revenue department. There's nothing has been mentioned. And because of that, my lord, issues were not framed. Factual issues were not framed in the lower court also. For the first time, my lord, he is raising that issue during the stage of, after the pleadings, much after the pleadings, he is raising it. And my lord, in this respect, my humble submission is, since that is not a pure question of law, it involves question of fact, my lord. The factual question involved is whether approval was given for such allotment by the Mizoram government. Even though there is clear hint, my lord, that approval was given because the land revenue itself has the map of the land. But supposing...
No, but then in the evidence, he has also admitted that he also got the allotment from the village council.
Correct. That's also done. So that is the other one, my lord. And regarding additional evidence, my lord, I will not produce any more judgment because I already produced yesterday, my lord. I think your lordship has already got it. And finally, my lord,
So I think you have given no photocopy. His first citation.
Additional evidence, my lord.
Regarding the additional evidence.
The additional evidence, my lord, is reported in 2022, volume 7.
This one. Yes. This one, all this you get photocopies, okay? The particular.
Yes, the relevant is at page number 250.
Yes,
I'll not read this one again, my lord.
Yes, yes.
And my lord, finally, this is the last judgment. This is reported in 2014 to SCC 269. Now, the relevant portion is from page number 275, my lord. Union of India versus Vasikuk, my lord. I'll read from paragraph number 15.
Paragraph 15.
Yes.
Yes.
Paragraph 15 onwards. It is tried law that in a suit for declaration of title, the burden always lies on the plaintiff to make out and establish a clear case for granting such a declaration. And the weakness, my lord, the reason I'm saying the weakness is because even if our defense was not accepted, my lord, and the weakness, if any of the case set up by the defendants, would not be a ground to grant relief to the plaintiff. The High Court, we notice, has taken the view that once the evidence is let in by both the parties, the question of burden of proof pales into insignificance, and the evidence let in by both the parties is required to be appreciated by the court in order to record its findings in respect of each of the issues that may ultimately determine the fate of the suit. The High Court has also proceeded on the basis that initial burden would always be upon the plaintiff to establish in the case, but if the evidence let in by the defense in support of their case probabilizes the case set by the plaintiff, such evidence cannot be ignored and kept out of consideration. At the outset, let us examine the legal position with regard to whom the burden of proof lies in a suit for declaration of title and possession. And then it goes on, my lord, and then it goes on and on. In a suit for declaration, if the plaintiffs are to succeed, they must do so on the strength of their own title. In Nagar Palika Jind versus Jagat Singh, this court held as under. The onus to prove title to the property in question was on the plaintiff respondent. In a suit for ejectment based on title, it was incumbent on the part of the Court of Appeal first to record a finding on the claim of title to the sued land made on behalf of the plaintiff. The court is bound to inquire or investigate that question first before going into any other question that may arise in a suit. The legal position, therefore, is clear that the plaintiff in a suit for declaration of title and possession could succeed only on the strength of its own title, and that could be done only by adducing sufficient evidence to discharge the onus on it. irrespective of the question whether the defendants had proved their case or not. We are of the view that even if the title set up by the defendants is found against them in the absence of establishment of the plaintiff's own title, the plaintiff must be non-suited. We notice that the trial court as well as the High Court, rather than examining that question in depth as to whether the plaintiffs have succeeded in establishing their title on the scheduled suit land, went on to examine in depth the weakness of the defendant's title. The defendants relied on the entries in the GLR and their possession or repossession over the suit land to non-suit the plaintiffs. The court went on to examine the correctness and evidentiary value of the entries in the GLR in the context of the history and scope of the Cantonment Act 1924 and the Cantonment Land Administration Rules 1925, and tried to establish that no reliance could be placed on the GLR. The question is not whether the GLR could be accepted or not. The question is whether the plaintiff could prove its title over the suit property in question. The entries in the GLR by themselves may not constitute title, but the question is whether the entries made in the Exhibit A3 would confer title or not to the plaintiff. This court in several judgments, my lord, this might also be relevant, my lord, has held that revenue records do not confer title in cooperation.
I was just looking for this,
Yes.
because there are several judgments which says that even Jamabandi,
Yes.
Patta cannot be proof of title.
Conferment of title.
Yes.
So it
cannot
goes
confer
on, my lord,
title.
and finally, my lord, I will not read because your lordship already knows this, my
Yes,
lord.
yes.
And paragraph 24, my lord. Paragraph 24. Because 25 talks of rights. In 23, paragraph 23, my lord, I'll read from paragraph 23, my lord. We notice that the above principle laid down by this court was sought to be distinguished by the High Court on the ground that in none of the above mentioned judgments is there any reference to any statutory provisions under which, because I think my learned friend might make this defense, my lord, under which revenue records conferred therein, namely revenue register, settlement register, Jamabandi registers are maintained. The High Court took the view that Exhibit A3 has evidentiary value since the same has been prepared on the basis of the Hyderabad Record of Rights in the Land Regulation 1358 Fastly. It was also noticed that columns 1 to 19 of the Pahani Patrika is nothing but record of rights, and the entries in columns 1 to 19 in Pahani Patrika shall be deemed to be entries made and maintained under the regulations. We are of the view that even if the entries in the record of rights carry evidentially value, that itself would not confer any title on the plaintiff of the suit land in question. Exhibit X1 is Classer Register of 1347 Fastly, which record, according to the trial court, speaks of the ownership of the plaintiff's vendor property. We are of the view that these entries as such would not confer any title. The plaintiffs have to show, independent of those entries, that the plaintiff's predecessors had title over the property in question, and it is that property which they have purchased. Now, my lord, my humble submission in this, because the facts are not the same, but what I'm trying to say is, my lord, independent of the land settlement certificate, my lord, he has to also show, my lord, that he has rights over the land in which I am occupying. And my lord, we are not against them having the big portion of land. They, as per the approved plan, my lord, we have seen that the portion they are going to hold is double the amount we are going to hold. A bigger portion of land. We have a small portion of land, my lord. And so our humble submission, my lord, in this respect is that the suit should be allowed to, the appeal should be dismissed. So, my lord, with that, my lord, my humble submission is, my lord, that the appeal should be dismissed and that the lower court's judgment should be allowed to stand.
Yes, any reply?
Yes, with the Lordship's permission, Your Lordship, I have quite a lot to reply, my lord. First of all, Lordship, regarding that no relief can be granted beyond pleadings, Your Lordship. Regarding that, my learned friend, if he is not aware of the settled position of law, I think he is trying to misguide Your Lordship. For that, my lord, I'd like to, apart from that citation which I placed before Your Lordship earlier, my lord, I place reliance again regarding CPC procedure, my lord. That also says that no relief can be granted, my lord, beyond pleadings. That is a settled truth, my lord. In a good number of cases, the apex court held this, both in writ petitions and also in trial cases of trial court, my lord. For that, my lord, I'll place one citation regarding that, my lord. I thought that would not be necessary, but now since that is now raised again by my learned friend, supposedly, I don't know
No,
why.
but do you deny that the Mizoram Civil Courts Act says that CPC is applicable in spirit?
In spirit means, let me ask my learned friend, even if it is spirit, what to follow? There is no separate or any other separate law. There is no other existing law. What we have to follow is, even though we said it is spirit, we have to follow the letters, my lord, of CPC. What else should we follow, my lord? There is no other law prescribing the procedure in civil court, my lord, to follow. No, there is nothing, my lord. It is ultimately the provisions of CPC. For example, now, my lord, my learned friend just finished reading the impugned judgment. Herein also, my lord, when issues were framed and some issues, my lord, were found irrelevant, the learned trial court, again, my lord, hearing this impugned judgment itself follows the CPC procedure as per procedure of so-and-so, section so-and-so, then I refrain.
Definitely, CPC procedure
Yes, my
will
lord.
guide. But we have the same situation in Nagaland also. Because earlier CPC was applicable only in spirit. So certain things have been just
Then, my lord,
overlooked by the courts.
For that, my lord, if we are to accept that this one as a WS, my lord, there is no verification, there is no affidavit, and there is no counterclaim also, my lord. If there has to be a counterclaim, it is not only against the plaintiff submitted, my lord, it is not only objection to my plaintiff. There has to be a counterclaim to get relief, distinct fresh relief, my lord, as was granted by the impugned order, my lord, judgment. There is no counterclaim. And counterclaim, if we speak about counterclaim, there has to be payment of ad valorem court fee. That is not exemption, my lord. There is no exemption of, even though we are supposing but not admitting, my lord, now, we now do not need to stick to the literal procedure of CPC, my lord. But still, we have to make payment of court fee, my lord. That is a practice now here. We have made payment. Now, if I made a counter...
Did you raise this objection before the trial court also? Regarding
No, my
the
lord,
WS?
this copy of this is, my lord, not supplied to us, my lord. For that, my lord, I'll take lordship to the deposition made by the defendant himself, my lord. They are trying to put things which are not there at the time of trial, my lord. And regarding this additional document also, my lord, there is a judgment of the PX court, my lord, which I'd like to show to your lordship now. And before that, my lord, if I may take lordship to the deposition of the defendant number one, my lord, the defendant himself, my lord. Page number 46, my lord, 46 of the book. This is cross-examination of the defendant respondent, my lord. Then he exhibited some documents which he said he relied on, my lord. There, my lord, DW1 is a copy of order dated so-and-so, or D2 is so-and-so, copy of letter, D3. Where is, my lord, the alleged WS, my lord? Not exhibited. Where is the WS? Because it was not served to us, my lord, at that time. And we only got it only lately, even after this one. So actually, these never come to our knowledge, my lord. It was slipped in the case record, my lord, at some point of time. That we are not aware of. That is why, my lord, for us, there is no chance to challenge this also. We are not aware of also. Unexhibited WS, how can we rely on that, my lord? Even supposing that he need not to follow all the procedures of CPC, he has to exhibit it, my lord, isn't it? No, it is not there. Not to mention about the counterclaim, my lord. So, even if we are to accept this, it is not there in the evidence. It is not there in the evidence, man. We cannot accept this. Number one. Number two, if he is making any counterclaim, he has to make payment of ad valorem court fee also. No payment is there. Court fee is not exempted to anyone in Mizoram. Even the tribal, the poorest tribal will have to pay. The only thing that they can get is delayed payment. That also before judgment, my lord. They have to pay. There is no complete exemption to anyone in Mizoram to court fee. There is no payment of court fee, even if we have to accept this. No payment of court fee. So if I make a counterclaim in any suit, my lord, I have to, my position will be transposed as a plaintiff as far as my counterclaim is concerned. Isn't it, my lord? So I became transposed as a plaintiff, and then the original plaintiff will have to file the WS in my counterclaim. That is the practice. But there is no counterclaim. There is no payment of court fee. And this is not also exhibited in his deposition. He has not exhibited. That means there is no WS, there is no counterclaim. So
no, we do admit that it was badly handled somehow on behalf of the respondent. But should that take away his right? In the interest of justice, in the interest of justice, if the court finds that he has some right, even if it was badly handled by the council, and if even if there were some procedural errors, should the court ignore if he has a right? I mean, that is also
actually,
a question.
my lord,
that is also
right
a question.
comes only after title is given to him, my lord. Right comes only after he has a title. If I boldly go to my neighbor's land and build a house, he will definitely go to court, my lord, for my eviction.
No,
And
but the evidence shows otherwise.
that evidence,
The
my lord,
evidence shows otherwise.
that evidence, we have denied it, my lord. The signature, the purported signature of the newly enclosed document, we have not admitted. That is another part I'd like to object.
No,
my lord.
evidence and examination in chief and cross-examination. That's all the court has to see.
Yes, regarding
So-
that, my lord,
so
yes.
that
Some
rebuttal-
step was taken, Master.
That-
That your lordship is correct. Some
Rebuttal
step,
has to be there. Rebuttal has to be there.
yes, we have rebutted, my lord.
And that chief examination in chief has to be demolished in the cross.
We have done that, my lord.
but-
We have done that. We have done that. But the part that we admit, my lord, I frankly admit is that there was some procedure for redemarcation. And we admit that they also summoned my client, I said myself. They summoned me to come to the revenue court. And they made some procedure on behalf, I don't know how they do it. But I did not put signature on these documents, my lord. I admit that actually when they built their house on the land, my lord, I made a complaint for their eviction and I went to the revenue department. And instead of evicting him, my lord, they took steps for him, my lord, based on the earlier allotment made by the village council authority, my lord. Made by village council authority, my lord. And regarding my pass, my lord. My pass, my lord. This pass was made from the original house pass revenue pass, my lord. Page number 5 of the paper book, my lord. This is my LSC, my lord.
This is the LSC.
Yes. Down there, my lord, in the middle, you will see this superseded house pass number, LSC number, this is not LSC, my lord. This superseded house pass number 534 of 2004. Way back in 2004, I was originally issued house pass by the revenue department, my lord. So my pass is not a direct LLC also. It was legal, lawful procedures were taken by the revenue department, my lord.
Okay. So now you submit on the additional evidence you were saying. You were
Yes,
saying
Your
that
Worship.
you have a judgment.
Before that, my lord, regarding my learned friend citation that revenue records are not pass title.
Does not confer title.
Exactly, my lord. regarding my lord, that I'd like to place some citation regarding that, my lord. Even though I am not ready with, I have it here, but I have not supplied to your lordship now. That may also be taken if your lordship thinks it require, my lord. These judgments of the apex court, my lord, cannot mechanically be adopted, my lord. It has to have similar factual situations, my lord. Otherwise, I cannot rely on judgment of the apex court.
No, but that is settled law.
I know, man.
That
I know.
revenue records do not confer title.
Yes, I know.
Yes.
But, my lord, it depends on different state land laws, my lord. In that case, my lord, there was no similar provision as found in Mizoram law, my lord. I'll take lordship to this provision, lordship.
It is only the civil court which can declare the title, which can confer the title.
That is why, my lord.
In law.
Yes. But, my lord, there is a law. That is why I placed this specific act for your lordship to peruse, my lord.
Which act?
The Land and Revenue Act 1956, lordship. This is the relevant act. I think I have placed my citation. 1956 Land and Revenue Act. Earlier one. I would like to distinguish, my lord. I would like to distinguish the case herein from those cases wherein revenue entries doesn't by itself confer title, my lord. But here in Mizoram, my lord, the law itself, which is to challenge at that river time, my lord, and which hold the field, my lord, says otherwise. London Revenue Act of 1956, my lord.
Yes.
Section 12, my lord. This is very important. That is why
Yes, you have read this earlier also.
that is why, my lord. Legal ownership over land.
Local ownership.
It is legal, my lord, legal in my copy. It has to be legal, my lord. No, can
In this copy, it says local. It says local ownership.
Anyway, I'll read, my lord. Possession of such certificates showing details of boundary of area and assessed revenue to be paid annually shall be deemed to be the conclusive proof that the land has been settled with the holder of the certificate and that all rights and
No,
interests.
Similar provision is there in all other states' revenue acts. Even in the Assam Land Revenue Regulation, this is there. But in spite of that, the courts say that this cannot confer the title. That only the civil court can confer the title. Okay, it gives you a certain right, no doubt.
It's conclusive.
Possession
It says
of-
conclusive proof, my lord. But if the statutory provision says so, my lord, unless that is there is any law which struck down this provision, my lord, any judgment from any court, my lord, which struck down this provision, unless that is struck down, my lord, it will stand, isn't it? Unless this provision is challenged, my lord. Conclusive proof. It says specifically conclusive.
Okay.
So regarding, my lord, the additional documents, my lord. Number one, they themselves admitted frankly that those documents were in their possession since 17th of June, 2016, my lord. At that time, the case was hot in pursuit, my lord. And they themselves agreed that they got it at that time. And they have not made any attempt, my lord, to submit it and file it and incorporate those documents into the documents of this court, my lord, in the present case. So they are now, my lord, stopped by the provision of Order 41 Rules to 27 AA, my lord. For that, my lord, if I may read this citation, your lordship.
Yes.
In 2014, 13 SCC 4680, lordship. Para 4 and 5.
Yes. Para 4.
4 and 5, lordship. Yes. However, if I may read, lordship, we do not feel impressed with this argument and deem it fit to reject it in view of Order 41, Rule 27(1)A, which clearly states as follows: the party seeking to produce additional evidence establishes that, notwithstanding the exercise of due diligence, such evidence was not within his knowledge or could not, after the exercise of due diligence, be produced by him at the time when the decree appealed against was passed. On perusal of this provision, it is ambiguously clear that the party can seek liberty to produce additional evidence at appellate stage, but the same can be permitted only if the evidence sought to be produced could not be produced at the stage of trial, in spite of exercise of due diligence. They have not made any attempt, my lord. Due diligence, and that, my lord, the evidence could not be produced as it was not within his knowledge and hence was fit to be produced by the appellant before the appellate forum. It is thus clear that there are conditions precedent before allowing a party to adduce additional evidence at the stage of appeal, which specifically incorporates conditions to the effect that the party, in spite of due diligence, could not produce the evidence, and the same cannot be allowed to be done at his leisure or sweet will. 2010, volume 13, my lord. Another citation, if I may be allowed.
Oh, 2010.
Now it's 10.
2010, 13, CC 487.
487.
Yes. This is for regarding additional evidence.
The same, my lord, because I have to make amply clear, my lord.
Yes. Para?
Para 16, your lordship. I'd rather go to 17, my lord. It is more relevant. It is equally well settled that additional evidence.
Wait.
Paragraph number 17, lord.
Yes.
It is equally well settled that additional evidence cannot be permitted to be adduced so as to fill in the lacuna. Now they are trying to fill in the lacuna, my lord. That cannot be allowed in law, my lord. They are now trying to fill in the lacuna which they have not made in the during trial, my lord. That, as the apex court says, cannot be allowed in law, my lord. To fill in the lacuna or to patch up the weak points in the case. Adducing additional evidence is in the interest of justice. Only, my lord. So they cannot use it, my lord, to fill in the lacuna or their weak points, my lord. That cannot be allowed in law, my lord. And I continue, my lord. Evidence relating to subsequent happenings or events which are relevant for disposal of the appeal. However, my lord, it
In
is
this
not
case,
open.
In this case, it was not subsequent, but, isn't it?
My lord,
It was already there during the pendency of the trial also.
Yes, they have not- my
It
lord,
is
they have
just
not
that they
made-
could not obtain it.
Yes.
Of course,
They-
something was mentioned in the evidence.
They said that they have
Verbally.
applied for some documents that they have not got it. But only 9 days later, 8 days later, they got it, but they did not make any attempt to produce it before the court, my lord. And however, my lord, there, page number 494, my lord. It is not open to any party at the stage of appeal to make fresh allegations and call upon the other side to admit or deny the same. Now, they are saying that I have gifted them, my lord. That is not in evidence, my lord. That is not allowed, my lord.
Not exactly gifted, but then decided to slice out a
Oh, my
portion.
lord, they tried to produce documents saying that I had gifted them, my lord. Herein at page number that my learned friend has just shown to your lordship, which is saying that I purportedly, they alleged that gifted them and slice it out. Otherwise, they cannot do it unless I gifted them, my lord. They have not bought it from me, my lord. And there is only one condition in which my LLC can be cancelled by the state also. If I make any I made any wrong use of the land, my lord, only then that can be cancelled. But that also is not done in my case, my lord. They try to say that I gifted them, my lord. That is a fresh allegation, my lord. Here, page number 24 of their additional document petition, my lord.
Yes, yes.
And
That
23
you,
also, my lord.
that you have given them, that you gave them a plot.
Yes, 23 and English translation is 23, my lord.
23.
This, they purported that my signature is there and I gifted them, my lord. That is not there in the evidence, my lord. And this is a fresh allegation, my lord. They never said that I gifted them, my lord, during evidence time. And page number 24 is also there. English translation is there, my lord. Then my signature is, my purported signature, they obtained it down there, my lord. Those I deny, my lord. I never gifted them. There is no evidence at all during trial, my lord, which says that I gifted them. And that is why, my lord, if we go through all the paper book, my lord, there is no word saying that I gifted them.
Yes, yes, definitely. That is not disputed. Those were never brought up during the trial.
Yes, that is a new, fresh ground that they try to lead me before your lordship. And regarding the power of village council, your lordship, power of village council to allot land, my lord. I admit, my lord, that during 1993 to 94 or 95, sometime like that, the village council authorities of that area, my lord, had made some plots on their own, my lord. And I was given one where I now reside, my lord. And they were also given somewhere, but the exact place I cannot say, my lord. Maybe next door to me, my lord. That I cannot say. But that actually does not have any authority in law, because way back in 1971, my lord, the government of that time, my lord, in Mizoram, made this executive order, which I supplied to your lordship earlier, my lord. This is standing, my lord, at that time, at the given time, which says, my lord, I think.
Yes, it was given.
To your lordship. And that is also, my lord, part of my objection to this additional document, my lord. It is there. It is the copy of the.
That order dated 23/12/71.
Yes. I enclose it here, my lord, in my written objection, my lord. I enclose it there, my lord, in my written objection.
Written objection before the trial court?
to this application for inclusion.
Oh,
of
acha, 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 in your, okay, okay.
Yes.
In that additional affidavit, okay.
I think you have got it, my lord. That is a
Yes,
standing order
yes,
of the government, my lord, standing order. Under section 3.1 of the Lusai Hills District House Site Act as amended, the Executive Committee of the Mizo District Council is pleased to declare all the lands within the jurisdiction of the Village Councils of Luangwal, Tansil and Sakaroti Chun shall henceforth be protected area within the meaning of the said act. No allotment of land for residence, trade, agricultural lands or other purposes within said area shall be made by the Village Councils without previous sanction of the Executive Committee of the Mizo District Council. This order shall not bar the village councils from distributing ordinary Zoom lands for a year within their respective jurisdictions. So from that time onward, my lord, allotment of land by the village council authority in those areas were not allowed. This was a standing order, my lord.
Yes.
Then regarding registration of my land friend, time and again keep saying that registration act was not used at that time. That, my lord, is a wrong submission, my lord. But that, I think, was a little misplaced, my lord, in submitting that one. If your lordship take a look at this registration act, my lord, it extends to the whole of India, excluding Jammu and Kashmir. So section 17(1) says that all instruments of gift shall be mandatorily registered with the registering authority. Section 17 of the Registration Act 1908, my lord. It is there, my lord. It is a statutory provision which we have all to follow, my lord. And one thing, my lord, regarding this adaptation of laws in Mizoram, my lord, we earlier, my lord, used to apply all those documents which are specifically adopted by the legislative assemblies of Mizoram, my lord, earlier, my lord. But, my lord, when the separation of judiciary had practically taken place since 2005, my lord, 2005. There was the separation of judiciary from the executive, my lord, since 2005 in Mizoram, my lord. Since then, my lord, all the central acts, my lord, are applicable in Mizoram since 2005, my lord. That is admitted fact, my lord. Since 2005, separation of judiciary was implemented in Mizoram. And then since then, all the central acts are applicable, my lord, unless they need to be specially adopted, my lord. So whenever any act says it extends to the whole of India, it extends to Mizoram, my lord, from 2005 onwards.
Okay. Yes, anything else?
I used to jot down the points somewhere here and there, my lord.
I think you have covered everything now.
I think my earlier submission, I think I need not cover it again.
No, no, don't. This is only for a reply to clarify.
Yes, reply to whatever my lord
what the defendant has said.
Had raised, my lord. And regarding, my lord, that map, that my learned friend used to rely on, my lord, map prepared by.
Yes, that map.
Yes. During trial, my lord, that is not there, part of the report, my lord. I do not find here, my lord. Where is the
No,
map?
that map was exhibited, but then the plaintiff said that it cannot be accepted because it's a photocopy, that it is not the original.
Yes, my lord. And all the documents, yes, as your lordship has now said, all the documents which they try to exhibit are all, even though they actually did not confer them any title by themselves, my lord. They themselves also are only photocopies, my lord. No original was produced.
They don't have to prove their title. You have to prove your title before the trial court.
Yes, my lord.
Because
Please-
burden of proof is on the
Please
plaintiff.
kindly go through my exhibit, my lord. Is there any, I have duly proved my title, my lord, for that, yes, my lord. Please kindly go through my examination, my lord. There is
Yes,
no
yes,
successful
we have seen-
rebuttal, my lord. There is no successful rebuttal even in the cross-examination. Everything I produce, the original of my LSC, my lord. And what else do they need, my lord? Now, if I may take your lordship to the Evidence Act, my lord. Evidence Act. Section 62, my lord. Primary evidence.
Yes.
Primary evidence means the document itself produced for the inspection of the court. I have produced the original LSC, my lord, before the trial court. So it's proved. And if we go through the cross-examination, there is nothing else to rebut, my lord, so, or falsify whatever statement I have made regarding my LSC. So I duly proved it, my lord. Actually, the landed trial court has to declare me as a legitimate owner of that landed property covered by my LSC, my lord. Now, we have got instead a perverse judgment, my lord, not relating to the documents on record in that case, my lord. So, if I may take again lordship to section 92, my lord, 91 of the Evidence Act, my lord.
Yes.
Yes, the more relevant will be, my lord, 92, section 92.
Exclusion of evidence.
Oral agreement.
Oral
my lord.
agreement.
When the terms of any such contract grant, now we are talking about grant of LSC, my lord, grant of title, my lord, or other disposition of property or any matter required by law to be reduced to the form of a document, my lord, title to a land, regarding title to a land, the law requires that it has to be reduced into writing. So we are now specifically concerned with this provision, my lord. That is why, my lord, required by law to be reduced to the form of a document have been proved according to the last section. No evidence of any oral agreement or statement shall be admitted as between the parties to any such instrument or their representatives in interest for the purpose of contradicting, varying, adding to, or subtracting its terms. So, my lord, now in terms of section 91 and 62, I have proved my LSC. So the learned trial court ought to have, my lord, should have, it have to declare me as a legitimate owner of the land by producing the original of that LSC, my lord. Whereas the defendant, my lord, did not even exhibit any original document. They did not exhibit any written statement also, my lord. What case do they have, my lord? They did not even exhibit their written statement, which actually even not admitting, but supposing, I admit, supposing if it's taken for perusal, my lord. Which is not, my lord, exhibited, my lord, by himself also. So he has no written statement, my lord. No counterclaim. No court fee is paid. court fee is, my lord, mandatory, even if CPC is not literally applied, my lord. Even though, supposing we follow CPC only in spirit, but court fee, no court fee is paid, my lord. No WS is executed. How can they have any case? Whereas, on the other hand, I have a duly issued LSC, which is also not a direct LSC, which was arising out of one house pass earlier issued in 2004, my lord, by the Revenue Authority. The Revenue Authority is the competent authority in the state for allotment of land. So they do it, my lord, and I produce the original to the court, my lord. And the action of the court, the state government, my lord, they have not challenged issuance of that LSC, my lord. They have not challenged, they have not filed a suit against me also for issuance of LSC. They said that it was wrongly issued, covering their place. And they also have not sued the state government in the Revenue Department, my lord.
And what is this Union of India versus Ibrahimuddin and another? There are some judgments in the file.
I think I have not placed it.
Oh, this is regarding admission of the.
I think so,
at the-
because
yes, yes,
we had argued on admission before Justice
Okay,
Murray.
okay,
before.
okay.
Yes.
So that was produced at that time. I think.
Yes.
Okay. Done.
Most substantially covered, I think, my lord. Please, I think, Lordship.
I think I've heard enough. Yes, heard Learned Counsel for the appellant, Mr. Such and Such. Also heard Learned Counsel. Your names, I always forget your names.
C. Zoram Sana, my lord.
C. Zoram Sanghan, yours?
And my name is Joseph, my lord.
Joseph.
Yes,
Okay,
easy
Joseph.
to remember.
That's easy to remember. Joseph Such and Such. Stop. Hearing is concluded. Judgment reserved.
And if I may make a
Please.
mention, my lord, regarding item number 4.
Yes.
My lord, if this matter can come up next week, because
Yes,
I don't
yes.
think we can
I
do
don't
it this
think
week.
we'll be able to take up anything now this week.
Yes, my lord. So, item 4 for next
Your
week.
Lordship is
Or after a week, my
little
lord.
burden.
Every day I've been taking up cases, and it's difficult for us to carry the files to another bench, you know. Sometimes the files are so bulky.
Yes.
Yes, item 4, list the matter before, list the matter next week.
Next week, my lord.
List the matter next week on the request of the Learned Counsel for the parties. Any other items left?
And also, my lord, one other matter is there. I'm sorry, my lord.
Yes.
Okay, I think item number 7 has been mentioned. Item 7, my lord, if it can be done after a week.
7 not mentioned, no?
After a week,
7 also after a week, yes. This is also on the consent of the parties, just say, no? And then, Court Master, this one you just send it like this, and these you just photocopy the relevant portion and send it along with the file, okay? This is here. And this one is